En ligne du comité de dérogation pour la Ville d'Ottawa. Welcome and good evening to this online hearing of the Committee of Adjustment of the City of Ottawa. The Committee of Adjustment is a quasi-judicial tribunal appointed by City Council to make decisions on certain types of applications under the Planning Act. My name is Anne Tremblay, and I will be chairing this hearing today. With me are my fellow panel members, Mr. Colin White, Mr. Scott Hindle, Ms. Kathleen Willis, and Ms. Julia Markovich. From committee staff, we also have with us this evening our Secretary Treasurer, Mr. Michel Benmont, and a coordinator with us this evening, Ms. Christine Papworth. Thank you. Before I begin, we have a number of comments to make. First, I'd like just to note that this hearing is through video conference. It's being live streamed through YouTube, and it will be archived along with tonight's agenda on the city's website. Also, in terms of the committee's purview, our range of jurisdiction, we can only, in fact, hear on matters that are directly related to the applications that are before us. So we really need to stick to what the question at hand is with regards to those applications. We also don't get into noise issues or property maintenance or property values or prosecution for illegal construction for that matter. We also will not entertain any personal comments about either a neighbor, an agent, an applicant, an owner. Those any kind of derisive comments of any kind will not be entertained or accepted. Also, in terms of additional variances, so should it happen that during the course of our discussions, we identify the need for either an additional minor variance or greater relief from one that's actually been circulated on the notice to the public. If that case occurs, then we really must adjourn that application and allow for a recirculation of the application to ensure that everyone has a chance to be advised of the accurate nature of that application. As part of the application process, applicants are required to provide us with statutory declarations that the sign has been, as required by the Act, has actually been posted on their property. We don't have any of those statutory declarations with us tonight, which means that we will need to essentially administer an oath or a solemn declaration that those sign postings have been done in accordance with the legislation. With respect to quorum, if quorum is lost at any point in time during the hearing, we will pause due to technical difficulties, obviously. We would pause the hearing, allow for the, hopefully for the technology to resolve itself. And if for whatever reason we can't regain quorum, and I'm talking about not having necessarily everybody back, as long as we have quorum back, then we can continue on with the meeting. If we can't, then we'll need to essentially reserve or retain those items that have not been heard and put them on to the agenda for the next regular meeting of the committee. Okay, so in terms of the hearing process, there's an agenda that was actually on your screen at the beginning of the hearing. We have some discretion with regards to what order we hear those items in, and we will in fact be doing that tonight. So the committee members do review the application materials before we actually get a chance to hear these in public for consideration. And but we make no decisions. So until we've had a chance to hear from the applicant, from any interested party in the application, whether it's for or against, we make no decision. We wait for this opportunity to get through that public process. The committee then, what we would typically do is we can either fast track an application, which is something that we've in a case where an application is very straightforward, or we can actually request a presentation from the applicant or the owner. And so what happens in terms of process, we'll get the applicant or the owner to do the presentation. from their committee members are the next to get a chance to ask questions, to get clarification, either from the applicant or from staff. Once all of that discussion is complete, we open up the public hearing portion, and we'll provide anyone who has an interest in the application to address the committee and to provide comments about any of your concerns or support. It could be support. So once we've heard from the public and we understand the nature of all the issues, then we will close that public hearing portion. We will then seek to resolve some of the questions that have been raised, either through additional questions to the applicant or staff. And from that point on, the committee will then deliberate and make a decision. So once we have made a decision, the committee's decision has to be provided within 10 business days of the hearing. So a formal written decision will go out that outlines what the reasons are for that decision. Then the public, anyone who has an interest, has an opportunity to, in fact, appeal the decision to the local planning appeal tribunal for a fee. So that said, just a few other instructions. To the members of the public, if you're joining us, I have a speakers list. I am going to follow that speakers list, but that doesn't mean that that's closed to anybody who might have decided to join us this evening. What I'll ask you to do in those cases is to state your name and your municipal address. And I remind everyone that there is a 5-minute rule in place. So that being said, that brings us essentially to the declarations of conflict of interest. Does any member have a conflict of interest either with any of the issues of this panel or any of the 2 other panels that met, panel 1 and panel 3? No. So for the record, there are no declarations of conflict of interest. We have no minutes to adopt at this particular point. So the only, I guess normally we go to adjournments. We don't have any on record right now, but I was hoping we could actually maybe speak with Mr. Mike Segreto about 910 Woodruff for a moment. Mr. Segreto, are you there?
Hello.
Hi, Mr.
Hello.
Segreto. I guess we just, we don't see you yet.
I am here.
So we had a couple of questions. And we just want to make sure that there's no additional variance required or greater relief than what's on the application. And I believe the issue has to do with the, what was the issue? Was the
lot width and height. Those were the 2 variances that we're asking.
Okay, it must be the height then, Mr. Segreto. So,
yeah.
So have we resolved through the plans exactly what that height requirement should be? In other words, I guess what I'm looking for you is confirmation that we don't need to amend the notice.
No, we've made all the proper corrections to it, and it is 9.5 meters that we're asking for rather than 8.
And you're comfortable that if it is approved, it would be tied to plans?
Yes, no problem at all.
All right. Anybody have any questions for Mr. Segreto?
Madam Chair, I believe there was some concern with respect to the front yard parking, and I think we've received some correspondence from.
Oh, yes. Thank you. Thank you for that reminder. That's right. So in this case, Mr. Segreto, and I guess I'm looking for also, is it Ms. Ramirez or is it Mr. Hodgins? Hang on. Ms. Ramirez. So we were looking at the site plan and we noticed that there seems to be a portion of the asphalt driveway that actually appears before what looks to be a portion of living space. Is there a minor variance missing here or not? Oh, you're on mute, Ms. Ramirez.
Madam Chair, the permitted parking or the legal required parking spaces are provided in the surface side yard. Surface side yard parking is provided. And so it is legal to park in a driveway leading to a legal space, and the spaces are identified as being 2.6 by 5.2 meters, which are the requirements of the zoning bylaw.
Okay, but I guess from our standpoint, it almost looks as if there's a portion of that that's actual. So if you look at the drawing, it says second floor above, and it looks like a portion of that second floor is actually living space.
So the front yard would be to the nearest point of the building, so the front wall there. And so the above, the living space above it provides protection, but the front wall there is defined as that point where it's the closest to the lot line. And so the front yard is in relation to that front wall.
Okay. Committee members, anybody want further clarification on that?
No, I think that's fine.
Okay, yeah.
All right, okay. That's all. We just wanted to clarify that, Mr. Segreto, before we move forward, because we didn't want to have you wait through the whole meeting and then only to find out that we needed to adjourn. So excellent. In that case, no adjournments. It's official. We're going to move on with our items tonight. Okay. So I'd like to start with number 1, and I am looking for Mr. Denami. Or they know? Hello.
Hello.
Good evening. So, all right. So before we go any further, then, Mr. Delorme, I've got to read a paragraph to you, and people are going to hear this many times over this evening. So it's an oath or solemn declaration. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee, that the sign was posted at the property to which the application applies, that it was posted for the prescribed number of days before the hearing, and that finally the post was, the sign was posted clearly and visibly, legibly the entirety of that time? Do you swear or affirm that to be true?
I do. I affirm that to be true.
All right, great. So perfect. We're not going to ask you for a presentation on this. The committee has had a chance to look at the application. So I am actually just going to open it up directly to questions from the committee. Anyone?
Madam Chair, yeah, I just had a question. I think the applicant submitted a request with respect to the conditions and reasons why we might not be able to simply apply these conditions at the time of site plan control. The site is subject to a subdivision agreement. It's on I think a fairly recently approved plan of subdivision. So there's a site plan agreement, or sorry, a subdivision agreement. And it strikes me that most, if not all, of these conditions should be able to be addressed at the time of site plan control approval through a site plan agreement. And I think we've just received some comment again from Ms. Ramirez concerning those questions, and it appears that that the only condition that the planning feels should remain, or at least the engineering group feels should remain, is the one with respect to serviceability of both sites. If the site plan,
so which condition then, Mr. White? I didn't get a chance to read that.
I think the only one that they're seeing should be retained is the one with respect to the site serviceability, which I guess would be, I think it's condition number 1, should remain as a condition of our approval. And I'm fine with that, given the circumstances.
All right, okay. So
Madam Chair.
Yes, Ms. Ramirez.
We would like to retain condition number 1, the servicing plan, as well as a site servicing report. So condition 1 and 2, we agree that the grading and drainage can be taken care of through the site plan process.
All right, so for the record, we're deleting condition number 3.
Yes.
All right, so again, I haven't had a chance to read some of the email chain that came up literally maybe an hour and a half ago. So on the difference between 1 and 2, Ms. Ramirez, what's the difference? What are you asking for?
So the servicing plan will show that they can tie into our infrastructure, and the site servicing report will show that we have capacity within the system.
All right, is that not something that you would look at, number 2, during the site plan process?
We're asking for it to be done in anticipation to show that both parcels have enough, both the severed and the retained parcel have enough, there's enough capacity within the system. So we would only look at the parcel that is going through the site plan control process for site servicing, but we want to look at the entirety of the parcel.
Okay, so I guess to Mr. White's point, if all of this was part and parcel of a plan of subdivision at some point in time, would there not have been studies undertaken to demonstrate that some time ago?
Through you, Madam Chair, there have been a pre-consultation for the site plan, and staff have also identified at that stage that we require this site servicing report. And the difference between doing it at site plan versus doing it now is at site plan, they would only look at the smaller parcel. Whereas if we have it as a condition of the severance, then we would look at the entirety of it.
All right.
Madam Chair, I think what I'm hearing is that there is a fear that servicing of this one of the parcels through the site plan approval process may or has the potential to result in a lack of ability to service the remnant parcel. Is that basically what we're saying here, and that we want to be assured through prior to the severance being granted that both parcels are serviceable, and that one doesn't compromise the serviceability, that one development won't compromise the serviceability of the undeveloped portion? Is that what we're, I guess that's...
Through you, Madam Chair, yes, that is correct. We would like that information, and if capacity is reduced within the system, we would prefer to have that information earlier rather than later.
Okay, it's still not making 100% sense to me, to be honest with you, if it was all by plan of subdivision at some point. But any other questions, Mr. Hindle?
My concern with these is mostly if the reports show that it's not possible, then I don't know that we necessarily want the severance to fail, because these reports, even potentially these reports, can't be done within a year. Does the applicant have any concerns with regard to that?
Through you, Madam Chair, I do. I mean, this went through a subdivision application. It went through a CDP process, the Canada Town Center CDP, that identifies development to be quite intense in that area. So I don't think serviceability should be of anybody's concern. And if it is, then through the subdivision agreement, there would be cost sharing involved for any upgrades that needed to be done. So the Committee of Adjustment don't think that's the right mechanism to, prove serviceability. I think the city is fully capable of doing that, but we're fine with the condition if it's needed.
Okay, thank you. Anyone else from the committee? All right, so think about it. We'll come back to it. At this point, if there's no further questions for clarification on the application, I'll move to the public portion. All right, so with that in mind, I have no speakers for this application, but is there anyone, any member of the public or other stakeholder that may have an interest in this application, either for or against? This is your opportunity. Okay, I'm not seeing anybody coming forward at all, so I'm going to close the public portion. And okay, so committee, you didn't get a long time to think about it. So we know for sure that we're deleting 3. I guess I would be actually inclined to delete number 2 as well. But I'm looking for comments. Ms. Willis.
I'm actually inclined to delete all 3 of them for the reasons given previously, that if in fact there's a serviceability issue, it's not really related specifically to the severance line, it's related to the development of the entire property, and to make it incumbent on the applicant to show that there's going to be something sufficient capacity within a year when he has to go through a site plan approval process anyway, I think could end up being onerous for him. So it's going to be caught. It's either going to be developed or not. And if there's a servicing issue, it's a matter of fixing that problem, and that really should not have an impact on the actual dividing line between the properties. So I would suggest deleting the 3 conditions.
All right, other thoughts?
Madam Chair, I would agree. I think these issues can be dealt with through the site plan review process. Reviewing of a servicing plan should include some analysis of the impacts on the adjacent parcel. If there are identified potential negative impacts of the development application, then it doesn't receive final approval. I'm inclined to support the concept of eliminating the conditions.
All right. I'm looking to hear from Mr. Hindle, Ms. Markovich, your thoughts?
Yeah, I would tend to agree with getting rid of both. I think I'm heartened, I'm helped with that, given that there is a holding symbol still in place on the property. I guess it would be on both new properties, that has a requirement for site plan, at least an application to be submitted, and that gives planning and growth management another chance to kind of make sure that the applications are in line with the plan of subdivision and all the greater requirements in the area.
Thank you. Ms. Markovich, did you want to weigh in on this one?
Yeah, I would echo the comments of the other members. I think the suggestion to delete all 3 conditions would be appropriate in this case.
All right. Ms. Ramirez, can I come back to you for just a moment? I believe it was Ms. Ramirez. Yeah. So my question to you then is, and Mr. Hindle raised a really good point about the holding zone. I know the holding zone is, the lifting is OP policy. There must be something in there that actually points to what those criteria are to, and can you just confirm for me that in fact the serviceability is one of the criteria for the lifting of the holding?
For you, Madam Chair, the criteria set out in the urban exception, and one of the requirements is that it's approval of site plan control and UDRP, which is our urban design review panel. And so there, yes, through that process, there is serviceability will be looked at.
All right, okay. Well, in that case, folks, I think it's pretty unanimous. We're going to, in fact, I think I'm hearing, so we're in consensus then, are we, for an approval of this application? And for the record, we are deleting all conditions. Correct?
Yes.
Yes, yes, we're good? Okay, all right. All right, so Mr. Denon, in fact, the application is approved and without conditions. So,
Perfect.
so yes, all right. Well, good luck with the site plan though. So hopefully a lot of those issues will be well resolved then, and there'll be no issues. So thanks so much for your time.
Thank you, Madam Chair. Thank you for the committee.
All right, thanks.
Bye.
Okay. Next one on our hit list for tonight is number 5. We're looking at 701 Churchill, and I'm looking for Mr. Alain. We have Mr. Alain with us this evening.
Hi, good evening, Madam Chair.
Good evening, Mr. Alain. So we've had a chance to look at the application. Again, we're not going to ask you for a presentation on this.
Okay.
So I'm just opening it up to the committee members to ask any questions that they may have. Anyone? Yes, Mr. Hindle.
So I'll just note that I think we saw a note from staff that we've been asked to tie at least to the site plan for proposed variances, especially in relation to the rear yard.
Right.
Do you have any issues with that proposal?
No, Madam Chair, I have no issues.
All right, thank you. Just to clarify that, is it just in relation to the rear portion or just in relation to the building envelope?
I think staff made the request in relation to all the variances. So it'd be in relation to the envelope writ large, because we do have a height variance here as well.
All right, so let's make it then in accordance, like in relation to the actual building envelope. Are we looking at Mr. Hodgins? Just need to confirm with you that's what we're looking for here.
Through you, Madam Chair, that's correct. That would suffice.
Okay, perfect. All right. Any other questions from the committee?
Excuse me, Madam Chair, we do need a statutory declaration on this.
Oh, thank you very much.
Good
I get on
catch,
a roll
thank
and
you.
then you forget all about it. So, okay, Mr. Ene, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed amount of time before the hearing, and that the sign was clearly legible and visible during the entirety of that time? Do you solemnly swear or affirm that to be true?
Yes, I do.
Which one?
Oh, I affirm that to be true.
All right, thanks. All right, excellent. Okay, so if there's no other questions by the committee on this, I am going to
Madam
open it
Chair.
up to the,
Sorry to interrupt.
Yeah.
I wonder if I could just ask a question of clarification with respect to the, I'm not clear on what the intent of the variance D, or that provision of the bylaw. Would it be possible for Mr. Hodgins to give us a quick explanation of that requirement in the zoning bylaw?
yes, Mr. Hodgins, I too was,
Sure.
I found that one interesting. It seemed like a bit of a new one on me, so please do explain that one.
Absolutely. Through you, Madam Chair, quarter lots in the infill 2 provisions, which are alternative rear yard setbacks, which were established as part of the infill 2 bylaw. Established alternative rear yard setbacks, especially there are some for interior lots, which is a percentage based, and for corner lots, it's a different requirement. I'm going to refer to the site plan here. I can't share my screen, but for corner lots in this area, they require a 1.2 meter rear yard and interior side yard setback. So on the applicant site plan, you can see that down the interior side yard and rear yard. However, they also need a additional yard, and it's in the corner of the two where they meet based on the proportion of the depth and the width. So alternatively to a traditional rear yard setback, which we see on interior lots, corner lots can make use of an interior and alternative rear yard setback, which looks more like a cutout in the corner with a 1.2 meter on each side.
Okay, all right, thanks. Anyone else for any questions on that one? Or on anything else? No? All right, as I was saying, for this application, I have no one on deck to speak, but this is the public hearing portion. So if anyone has, anyone out there wants to speak either for or against this application, please just raise your hand or unmute. Okay, I'm not seeing anybody here at all on this one. So with that then, committee, what say you?
I'm good.
Support?
In support.
Is it unanimous? All right, okay, so Mr. Ane, your application is granted. And I believe that you've read some of the comments that have come in on the file. There's a number of things. I guess the fact that you need a building and demolition permit, that there's 2 trees that may be impacted, and Hydro Ottawa has some comments as well.
Yeah, thank you, Madam Chair. We're familiar with the comments and are okay with them, and we'll continue to work through the site plan control process with the planner as applicable on those conditions.
And for the record, we are tying this this granting of the application to the plans as it relates to the building footprint.
Thank you. Yeah, we're comfortable with that. Appreciate
All right.
the clarification.
Okay, great. Well then, thank you very much.
All right. Thank you.
Have a nice
your
evening.
Take care.
Cheers.
Okay, so the next application then is number 6 and 7, and it is for 864 Woodruff Avenue. Can I see the Mr. Hume? No, I'm looking for, hang on. Which one is it? Number 6 and 7? I believe it's Mr. Hume, is it not?
I'm here, Madam Chair, and sorry about that.
Hello, good evening. How are you?
I'm good. How are you?
I'm very well, thank you.
Good.
Okay, so Mr. Hume, before I forget, the coordinators are really good about getting on me about this. No signed declaration has come in, so on that basis, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first on the property to which the application applies for the prescribed number of days before the hearing, and thirdly, that the sign was visible and legible the entirety of that time? Do you swear that to be true or affirm?
I swear and affirm, Madam Chair, that the signs were installed as per the procedures prescribed by the committee.
All right, thank you very much for that. Okay, again, in this case, Mr. Hume, we're not going to ask for a presentation. I do note, though, that we need a very minor correction to the application, which is really only to strike from the second line from the top legal description. We are going to strike parts 1 and 2 from that description.
Right, correct. Yeah, it shouldn't be, that's describing one of the parts as opposed to the parcel in its entirety.
All right, okay, thank you. Any questions for Mr. Hume on this application, on either the consent application or the application for variances? Mr. Hindle.
All right, perfect. I just had a question. Are these the first long semis along this portion of Woodruff that you're aware of, Mr. Hume?
Yes, yes. So yes, they are, and yes, they're the ones that I'm, the streetscape that we provided to the committee doesn't show any other long semis, at least in that block. And I don't think if we move further down towards Baseline Road that there are any in that block either.
Okay, no, that's fine. I was just curious. So as a result of that, the parts, I think it's 2 and 3 are to form an easement to access the parking in the rear.
Correct. Reciprocal easements.
Okay. Any other questions for Mr. Hume?
So in this case, the ownership would be front and back would be all under one owner.
Correct.
So we don't have issues with having to widen the easements in the rear for parking, I guess, in this case.
No.
Okay.
So right now, and the way the ownership is structured is that a single owner will own both back and front and on both sides. So it's a purpose-built rental project. So the intent is to hold all of the units in a single ownership at this point.
Okay. Great. No, that's all my questions. Thank you.
Anyone else? All right, I do have a couple of questions myself, Mr. Hume. I noticed that there's a number of people who have written in on this application. Can you tell me a little bit about your public consultation process?
So what the people have written in about, as Mr. Hindle pointed out, this is the first one that's happening on the street. But if you go across the street, there is another application that has been made, not to the Committee of Adjustment, but to the city for a minor zoning amendment to do it exactly the same thing, a pair of long semis. But in the case across the street, the lot is significantly smaller than the lot that's subject of this application. And there are other issues related to drainage and topography that have to be addressed. So when the applicant consulted with the city, he was recommended to move through the minor rezoning and part law control process. So they're going through that process because the lot is smaller and more compact. So that's what's been the genesis of the complaints across the street at 847, I think it is, Woodruff Avenue.
Okay, but there are some comments about, the level of intensification, disruptions to vehicle and pedestrian traffic, possibility that it might result in 8 units as opposed to 4.
So, I mean,
So-
if we look at the broad policy perspective that the city has adopted, and you layer that onto Woodruff Avenue, this is a place where intensification, and this is really minor intensification when you look at it from the city's perspective and from an official plan perspective. So, that's where they're looking to have intensification occur. This is 500 meters from the Carlingwood Shopping Center, which is going to be at some point in the future, not now, but will be a major transit hub. So when we start to talk about intensification, I think this is exactly where intensification should occur. And this is relatively, at least on this, it's intensification that is not only minor, but quite sensitive because of the size of the lot. You're not going to get your drainage issues. You're in fact improving the streetscape because you're, as you pointed out earlier on when you talked to Mr. Segreto, front yard parking, if you look at the streetscape, the streetscape's not dominated by anything but really front yard parking in a lot of cases. So what you see along this section is you're going to see less front yard parking. It's more hidden. It's much more sensitive to the streetscape than what you see now. So I think this is what the city's intended from an OP perspective, and I think it's actually quite respectful of the streetscape and the street conditions.
All right, thank you. Any questions at all remaining? No, I guess, okay. That being said then, I don't have anyone on my speakers list, but I want to give the audience out there, the public out there, the opportunity to come forward if they want to speak either for this application or against it. Is there anyone out there? Okay, I'm not seeing any hands. I'm not seeing anybody coming forward. So on that basis, I'm closing the public hearing portion. All right, so committee, back to us with regards to making a decision on this, on both the severances and the minor variances.
Madam Chair, can I just raise one minor point before you make your decision?
Yes, please.
There was a request by the city to impose a condition to undertake a noise study. I'm wondering if the committee would be receptive to modifying that condition, not requiring the study, jumping right to imposing what I believe would be the recommendations, which would be things like central air conditioning, double glazed windows, and notification to be included on title in the case of a sale and on leases in case of a rental, in case of a rental portfolio. We know that those are going to be the results. That's happened for other applications on the street. In fact, for 847, the city's received a noise study, which has recommended that. It just saves, it's a $5,000 savings, not a large amount of money, but it is a bit of savings, and you get the same result. So if the committee would be interested in that, I'd request the committee consider that as an option, if they would.
So I'm going to ask Mr. Hodgins to pipe in here, but I do have a comment about that. So one of the benefits, Mr. Hume, I believe, of having the condition read that you will in fact prepare a noise attenuation study, and that in keeping with their policies, and that you will then enter into an agreement on title, is because if we remove that and we go straight to here's the product, then you're literally forced into a situation within the next year where you have to have completed your designs, gotten your essentially done your study, and then moved on to building permit. So what happens with the development agreement is that all it does is buy you a little more time. And it's not, the clearance of the condition is the agreement, not doing and implementing in your plans the study.
I'm at your disposal, Madam Chair. We can do the study. It's just, we're trying to be responsible from a cost perspective. So
I guess, Mr. Hume, well, I hear what you're saying. So the only option that I could think, and Mr. Hodgins, just bear with me for a minute, I might be back to you in a second, but I think what I would suggest then is that it would be that you enter into a development agreement to do such and such and such and such a thing. And we could say that we could itemize that as part of what's going to be in the development agreement. But to be honest with you, it seems to me that I guess having to do the study would still be required. So, all right, so Mr. Hodgins, if we were, and I guess it's kind of jumping the gun, but I do know, Mr. Hume, what you're saying, central air conditioning, that kind of thing goes a long way to meeting some of these requirements. Mr. Hodgins, I guess I'm looking for you to weigh in on this one. Would you be as comfortable if we were to itemize under this condition the things that Mr. Hume is accepting to do?
Through you, Madam Chair, staff would prefer to keep the noise study condition. As you may be aware, planning, infrastructure and economic development developed a noise screening tool, which does allow for notices on title in certain circumstances, depending on the proximity from certain roadways and other noise sources. In this case, the notice on title wasn't appropriate. It was triggered instead that the noise study be required. So from the perspective of planning staff, we would prefer to keep the noise study in play there.
All right, thank you very much. Any other thoughts from the committee on this?
Madam Chair, if we had some evidence that similar developments taking place 3 or 4 doors down the street on the same street, subject to the same noise issues, I'd be inclined to agree with Mr. Hume on simply applying the conditions that were imposed in that situation. And I think he's right. It'll likely just be double glazing and insulation and ability to install air conditioning. But
okay, but the problem is we need to have that list now. So we would actually have to build it in right now.
I'm wondering for future reference if it might be possible to have that kind of information available to us when we're making a decision on these applications. Because if there has been an identical or some very similar situation down the street, it really doesn't make a lot of sense to have to engage another consultant in a $5,000 or $8,000 study that's going to say exactly the same thing as the development down the road.
All right, but we don't have that information tonight unless
I recognize that.
Okay. All right, other thoughts from the committee on that? Are we done? Ready for a vote?
Before you, well, you can vote or after you vote. This is my second virtual hearing, and I think that it's important as someone who appears before the committee to tell you what a good job your staff are doing with these applications. These are very difficult times, and your staff deserves some praise for their nimbleness as in processing these applications and getting things done so people like myself and my client can appear before your committee. You probably don't hear that very often, but I just thought that it would be important that you know that I think your staff are acting very responsibly and showing the right amount of nimbleness and flexibility to make sure that applications are processed in a timely and efficient manner. That they're doing a good job for you.
Mr. Hume, thank you so much for those comments. The committee recognizes that as well, but it is great when we can hear from applicants themselves publicly saying those things. That we thank you very much for having taken the time to say that. And we, like I said, the committee is very much in agreement with everything you've just said. So,
Thank you.
thanks
for the offer.
again. All right, so that said, I think you've got an application and it's unanimous that it's that both the consent and the minor variance applications are granted, but I don't see us waiving the noise study. So
I'll submit it next time. There is one across the street, and I should have had it and submitted it to the committee, and we could have dealt with it then, but so for next time.
all right, thank you. Mr. Hindle?
Yeah, what I might note is that applications 8 and 9 are just down the street. So there may be an opportunity for you to work with them to minimize the overlap between your two applications or between your two studies to at least share costs as much as possible.
Great. Thank you.
All right, excellent. With that, we wish you good luck. Thank you.
Very much, Madam Chair.
All right, have a nice rest of your evening.
Thank you.
Bye now.
Bye-bye.
Okay, so we're going to go to application number 2. Application number 2, and I am looking for Mr. Desain. Monsieur Desain? No, sorry, I'm looking for Mr. Enendu. My apologies. Looking for the agent, that's Mr. Enendu. Do we have Mr. Enendu here? Looking for the agent for item number 2, 112 Marie. All right. Hello, you're on mute.
I'm on mute. Am I
you're
on
not.
now?
Now you're good. Are you Mr. Enendu?
I'm Justin Inendo.
Ah, thank you, Mr. Enendu. So we're looking for a presentation on your application for tonight.
Okay, I'll make one.
Apologies, Madam Chair, we will require a statutory declaration.
Oh, yes, yes, yes. Thank you. So Mr. Enendu, we need either an oath or a solemn declaration about the sign posting from you. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies? Secondly, for the prescribed number of days before the hearing, and thirdly, that that sign was clearly visible and legible for the entirety of the time. Do you swear or affirm that to be true?
I swear that to be true, and I affirm.
Okay, so you now have the floor to present your application.
Like I had a cover letter, I would just like make my presentation from the contents of the cover letter. Like I was submitted this, the design of this place, it was in consonant with the vision of the city, which is part of it's called a Vision Veneer, Building a Better Revitalized Neighborhood Veneer. We have taken this into consideration. Hello, can you hear me?
Yes, we can hear you.
Okay. And in the last minute, there were a lot of, not a lot, but, some concerns raised by the neighbors. I think mostly the closest neighbor was 108, and his main concern did not really have any technical value to it. He said we were talking about parking and the rest. So, but in making this application to demolish the existing structure and to build in a three-story triplex, a three-apartment dwelling, we have considered, we carefully studied the city's vision for the streetscape, what is going on the street, and the vision of the city for this area. Therefore, we made our planning, the design, to fit into this, and we walk the street several times, seeing what is the other structures that are coming up along the street. We make sure that this fits into it. And the frontage, the landscape is in design to enhance, to go in line with the city's plan to revitalize Grenier. And I believe the proposed development meets the Ontario's 4 Planning Act tests in the way that the variances are minor. For example, the front setback, which we asked for, is just 1.38 meters, and it's because we had to meet up with the content, with the minimum square footage of the community area at the rear, and at the same time have parking. We are aware, like one of the neighbors complained about the parking. This is why we ensure that we have to provide parking in the rear, since the streets are almost already fully packed during the night time. And in doing this, and at the same time trying to get the minimum amenity area at the rear as per the code, the zoning bylaw. This is why the frontage, we had to shorten it a little bit. But that's, like I said, the 4 variances we have asked for are within are minor, and our design concept has already been submitted to the cities for permit, and it's undergone zoning, and the zoning comments had come in, and we are very confident that everything as it looks in the site plans is within the zoning, because the comments showed that it was very minor. They wanted the driveway. Our driveway was just 10 cm. It was 2.5 instead of 2.6. So those were very minor things. Right now, the adjusted site plan meets the zoning conditions. So we're sure that it meets this test too. And then the other part of the 4-way test, the design approach conforms to the vision veneer of the city's master plan for revitalizing this area. And the design approach of it is in conformance with the official plan. So we believe that removing the existing building to put in a triplex will make the best use of the existing lot, which has an old building now that is a single-story, single-family building. So I'm confident that the only issue we had, which I have to say thanks to Cameron, the planner, for going back and forth with me, several times up to this evening, when he now said yes, it's quite acceptable, was the height of the building. The area it's the difference in elevation between the rear and the front is quite significant. So he was worried that our building might be higher in the front than we have asked for. But I had given a detail, I had sent in a detailed plan, which I think he might have, he might pass on to you, because he said he was going to pass it on to the committee members. Giving clear clarification of how we will deal with the slope, which takes account that the front height will not be more than 9.7 meters. Being that the rear was higher. So he accepted this, and that was the major issue, I think. I believe that, granting this minor variance request will help greatly in improving the veneer and in accordance with the city's plan for revitalizing this area. And since we have tried very hard and kept in consonance with the zoning provisions, only seeking minor variance, which the zoning examination that was done by the building permit application we did had raised all the same issue for which I am asking for variance now. The only issue it raised that was outside was that of the drive-in space that was 2.5, and we made it 2.6. So I believe that it falls completely within the zoning issue, and we should not have it will not constitute any, how would I call it? It will not constitute an oddity from what is obtainable or from the plan of the city for this area.
Okay. All right, thank you. Are there questions for Mr. Anandu?
Yes.
Any questions? All right, well, okay, Ms. Markovich.
You mentioned there are 3 units proposed in this development. Can you confirm the size of those units? Are you looking at 1-bedroom units? What sort of configuration are you proposing here?
The average area, I think, was about 800 square foot, and there are 2 bedrooms, not 1 bedroom.
So you have potentially 6 bedrooms proposed and 2 on-site parking spaces. I just want to make sure I understand that.
Yes, each apartment is 2 bedrooms and it's 3 apartments. So we have 2 parking space. The fact is that the zoning bylaw for this area does not require a parking for a triplex as we are designing. But we are we are adding a parking as an incentive to being that the street is already kind of fully, there's a lot of street parking already. The zoning bylaw for here, with our consultation before we started the design, for this section of the near did not require a parking for a triplex. Parkings were required if we're doing more than 8 units. Yes, I'm very sure of this. I made consultation with the city, the DIO and the planner before we went into, before I even applied for, before we went into the design, and then the minor variance stage, which we are now.
All right, thank you. All right, any follow-on questions, Ms. Markovich, on that?
No, that's fine, thank you.
All right, questions, Mr. White?
Yes, Madam Chair. Question to staff. I noticed in their report, Mr. Hodgins has expressed some concern with respect to the variances with respect to lot area and lot width. And the report mentions that, goes on to advise that while it's typically not minor in nature, that there are a number of examples of similarly sized lots that have been developed in a similar way in the general area. And that I guess that this would not be out of character with those similarly developed lots. I'm just wondering, what's the zoning situation with respect to those? Are they legal non-conforming situations where they developed before the zoning bylaw, or the provisions that are included in the current zoning bylaw came into effect? Or have we got examples in this area where there have been similar, where approvals have been granted for similar types development? That's one question. I have another one that I'd like to follow up with as well.
It's me? Do you want me to?
No, for
sorry,
Mr. Hodgins. No. Yes.
Through you, Madam Chair. I'm not sure if, I would imagine most of those situations are illegal non-complying. I did not, however, go through each property and check to see if they were granted variances or the date of their construction. One property does have a urban exception on it, which means that they were subject to a minor rezoning to permit different form of development, but I'm unaware of in each property which has these developments if they were subject to minor variance applications or not.
So you're not aware of the history of the Vanier zoning in the area that may or may not have approved or allowed this type of development?
Through you, Madam Chair, no, I am not aware of the history of the former zoning prior to being our 4E commercial subzone.
Okay. Madam Chair, another question with respect to the, I just have some concerns with respect to the parking layout on the property, the 2 spaces at the back. It appears to me that, I'm assuming that these meet bylaw requirements in terms of dimensions, but it appears to me that maneuvering in and out of those spaces at the back would be somewhat difficult given the space that's assigned to them.
So Mr. Wood, that was exactly one of the questions that I wanted to raise as well, because looking at it, it seems very tight. So Mr. Anandu, you're an engineer, you're a PN, right?
Yes,
Okay. So can you confirm to us that you've done some sort of turning radius
yes,
in the back so that a car can actually move? Do you have those
Yes.
drawings?
yes.
Yeah,
There's a
those
software
drawings.
there's a auto turning software that is used in other designs. We used it a variation, a modification of it to try to turn into the second parking. I'm sure you're talking about the parking on the left, and we're successful without touching the building. But one of the things we're going to do was to add a bollard, a concrete bollard, just at the edge of the wall. That is one of the engineering ways to protect the wall, just in case somebody doesn't drive well. But I confirmed that, we did a test run, and it went through. Even though it looked tight, but it went through. So I decided that we're going to have a bollard at that edge.
Okay, Mr. Hodgins, did you look at that yourself? Did you get a chance to look at Mr. Anandu's analyses on that?
Through you, Madam Chair, I did not look at the analysis themselves. I did take a look at the zoning bylaw requirements and did not see any issues with, in terms of the zoning bylaw. I agree there could be, it may look tight on paper, but I did not see any analysis of that. Just confirmed simply that they met the zoning bylaw requirements for the space in Iowa.
Okay, it looks awfully tight. I agree with you, Mr. White. Looks
Yes,
awfully tight. So, Mr. Anandu, I guess, as a committee, we see these applications. And in some cases, if you're not even required to have parking, and I think that, I can look to Mr. Hodgins to confirm that, but I don't think you need any parking at all. So it seems to me that there's a couple of things that could be addressed here if we were to reduce the number of parking even by one, which would be to deal with your community amenity area, which was your reason for your front yard setback and a number of things. So to be honest with you, I'm not convinced without seeing those drawings that that the configuration actually does work. So I guess I'm looking for some feedback from the remaining members of the panel. Mr. White, of course, you're welcome too, but if it doesn't work, at the end, it'll be.
Madam Chair, I'm wondering, given that there is apparently no parking requirement here, do we really have to concern ourselves with the functionality of the parking that is being provided?
We don't, except for,
maybe we don't, maybe it's not maybe we don't have an issue on that. It certainly doesn't have anything necessarily to do with the minor variances that are being applied for here, as far as I can tell.
Well, I guess that's my point, is that in fact it is driving some of the minor variances because we're trying to fit these two parking spaces in. If it wasn't for that, there would have been plenty of room for the community amenity area. And then we would actually not have had to have I think it's the front yard setback. There wouldn't have been any variance required for the front yard setback. That's what I'm suggesting here. Mr. Hodgins, can you confirm that to make sure that I'm not saying something that's completely false to everybody? So,
through you, Madam Chair, parking is not a requirement for this property. It is in Area A on Schedule 1X. Therefore, no parking is required for the first 12 dwelling units.
But what about the amenity areas? So there's no variance for it, the community area or the amenity area.
Correct.
Is there a requirement for an amenity area in this zone?
Correct. For a 3-unit dwelling in this zone, and in the schedule it's in, they require 45 square meters of amenity area located in the rear yard, and I believe 80% must be soft landscaped, as shown on the plans.
Is that what we have? I'm just wondering.
Yes, that's what we have.
Oh, so sorry, Mr. Anandu. I think right now the discussion's between us and
I'm
staff,
sorry.
please.
Okay, I'm sorry.
Through you, Madam Chair, correct. As identified on the site plan in the rear left of the property, they do identify 45 square meters of amenity area, which would meet the zoning bylaw requirement.
And is that, can you confirm that that's really the reason why we're looking at a front yard reduction? Because in fact, that reduction is needed to bring the building forward enough to meet the amenity area requirement?
Through you, Madam Chair, difficult question, partially for two reasons. Is no parking is required for this property, so they could accommodate it that way. The other thing to note is there is an ability to use section 123 of the zoning bylaw, which is a front yard setback reduction based on the setbacks of the neighboring properties. The reason it wasn't raised in this example is it would have to be shown that the neighboring properties were developed in conformity to the zoning bylaw at the time. It was unclear to staff whether that was the case or not. So we just stuck with the variance itself. As noted in our report, we don't have an issue with the variance given the setbacks of the adjacent properties. So in terms of your question, it could be, it really depends on the design of the building here. There would be a way to accommodate it otherwise.
So regardless, so even if there was no parking, there could still be a case made for a reduced front yard based on the streetscape and, okay, fair enough. Any other questions from the committee? All right, Mr. Nandu, I do have another question for you. With regards to the consultation on this application, can you tell me if you reached out to your neighbors or anyone else before you came forward with your applications, or at least during that time?
The owner of this property told me that he did that. He spoke to the neighbors and they know that he's about to develop a project and they had no problem with that. In fact, he's indicated they were happy because their own property values will be raised with a new development in their midst.
Okay, well, we've got, we do have people on record that are opposed, and we do actually have someone who wants to come forward this evening. So Mr. White, I see that your hand is up.
My apologies, Madam Chair. I missed. I meant to follow up with this question. Looking at the zoning, I pulled out the zoning on it. It appears that the zoning here is R4E, and then there's a -C in the designator on the zoning map in the online version of the zoning bylaw, but I'm unable to find the meaning of that -C provision. I wonder if staff could help me there.
Through you, Madam Chair, I can reference the bylaw provision in a minute and I'll just pull it up, but it refers to enabling commercial uses. It's a commercial subzone in part and it's applied on certain areas mostly in the interurban area, and allows some sort of commercial uses. It doesn't restrict the residential uses, it just enables more commercial uses to be present. I believe on the street there are some examples of this.
Okay. Madam Chair, appears with the zoning, the R4E zoning that with a 10 meter, I think we're dealing with a 10 meter frontage, that a detached link, would be permitted use. Semi-detached would also be permitted, although that's 6 meter requirement for each unit. I suppose it would not accommodate that situation. And would a duplex? No, a duplex wouldn't be permitted. I'm just wondering what the development options are given the existing frontage, and it appears to me that this detached link is the only one that would be accommodated. Am I correct in that? Feeding the zone.
Through you, Madam Chair, if you just give me 1 minute, I will pull up the zoning provisions for the other possible uses in the R4 zone.
I guess my question is, anything more than one single unit permitted with the existing frontage that we have?
Through you, Madam Chair, Member White is correct. I believe that the 10.6 meter lot frontage would only permit a detached dwelling under the current zoning.
Okay.
Thank
All
you.
right. Can you just tell me then, just a follow-up question then, Mr. Hodgins, on that? When you say that and you compare that zoning to the remainder of some of the development that Mr. White was talking about earlier, is it all the same zone? Do they all have exactly the same zone applying to them?
Through you, Madam Chair, I believe all the properties on this street have the same R zoning, with the exception of one, which has an urban exception on it. Correct.
Okay, so in other words, none of them actually comply, I guess, going back to some of the comments we made earlier. So that, I mean, I guess that just goes to show, right? So there must be, I mean, yeah, there must be development that happened well before the zone was in place then. Okay, any other questions from the committee? Okay, we're going to go now to the public portion of our hearing. And I have Mr. Dessen, and I see you're here, Mr. Dessen.
Yes.
Good
Yes, I am.
evening. Bonsoir. Est-ce que, Monsieur Dessen, est-ce que vous voulez parler en français ou en anglais?
No, I can speak in English.
Okay, that's very good. Then in that case, I'm going to give you the floor to provide your comments.
Great, thank you very much. Well, I'm the neighbor of the 108 Marier, which is the property right next door to the applicant right now. And just for the record, nobody ever came to consult me to ask me my opinion about this. I just found the sign next door, and that's how I found out that this was happening. And I received a letter from the city. Thank you very much for informing me, because nobody had informed me. And my wife and I have been owning this property for the past 30 years. And just so you know, we bought it from father-in-law, my wife's father, who bought it almost brand new when the property was 1 year old in 1968. So we've been running this place for close to 30 years ourselves, and father-in-law for the other 20. And I can tell you, in terms of parking, I don't know if it's possible. I know you have somebody who could put perhaps one of the pictures there concerning the parking. Is it possible to display that picture for me?
Yeah. Ms. Papworth, do you have that?
One moment, Madam Chair.
Great, thank you. Yeah, because what I want to demonstrate is that right now, the way the parking is 2.17 meters. And I tried to go in with my little Toyota Matrix, and it wouldn't even fit in 2.16. So a parking in the back, I can tell you, over the past 30 years, I have seen the neighbor try to bring one car in the back, and that was it. I thought the car was going to die there because it never happened again. So a parking in the back with 2.6 meters the way it is proposed, you got to keep in mind that, as indicated previously, the property is not on flat land. There's a big elevation in the back. So driving in the back of that property would have to be almost in a tunnel, because I have a fence on one side and there's a house on the other. You'd have to be driving with 2.6 meters. And I can tell you right now, this will be almost impossible in the summer. And in winter, if there are any cars, they're going to be on the street, because there is no way somebody's going to be cleaning that driveway right down to an inch to the corner, because there's going to be too much snow. So parking, and I heard, all your discussion. Thank you very much. And I can only echo one of your members who said maneuvering a car in the back there would be almost impossible. So definitely, and the biggest issue we have been having as owner of our property is the fact that there is 2 garages on Marier Avenue right across from 108 and 112. We each have a mechanical garage, and there are cars all the time. So I can tell you right now, the traffic with the 112 Marier, which is vacant right now, has still been problematic. And if the new applicant thinks that he's going to be renting apartments to clients who don't have cars, I think it's theory. It's a very, very nice theory. But I can tell you, after 30 years of experience, this does not work. The client will tell you they won't have a car, and then they will bring a car. And then we're going to have a lot of issues in the future with parking space, definitely. That was my first point. I'm very, very concerned because right now we're getting people to call us all the time with problems with the parking. And this, the way the design is right now, I can tell you will not work even with the 2.6 meter that is proposed right now. My second concern is about trees. As you can see, actually, this is not my photo. It's the photo of myself. If you could show my photo, Christine, that would be much appreciated. As you can see on the property there, I have trees that, because of the two buildings, have grown kind of wherever there was some space. That tree that you see there is actually growing on my property and is basically coming through on the 112. I would really like to know what is the intent with those trees, because there's two of them, one beside the other, of my property that are going across. And I really want to keep those trees because they provide shade to my property. And just so you know, when I went yesterday, I got the biggest surprise of my life because I have in front of my property, like right at the corner, a beautiful lilac that was there, has been there for over 30 years. A lilac with a nice bushy top. When I got there yesterday, that tree had been cut to my property extensively, like over a foot on my property of the tree has been removed from the property on 112. I am not sure how this has happened, but I can tell you, I'm doing an investigation right now to find out how this was done and how somebody got on my property to cut my tree. But I really want to find out with the existing tree. I'm going to do my legwork on my lilac that got cut, but I want to find out what is the intent with the existing tree that they see there.
All right, thank you very much, Mr. Desain. I think, Mr. Renaud, I don't want to get into the lilac, so let's not talk about that because that's not within the committee's purview. But we did see the picture of the tree. Can you tell us what the intention is with that?
Is it me?
Yes, I'm asking you.
Yes, the intention is that if that tree is in his own property and it's growing over at 112, then I will ask the owner to relate with him. But our intention was to retain the tree. If you look at the site plan I have there, I had said to remain. The site plan says existing tree to remain. But if he has problems with it and he says it's his tree, and then we will give him his option. But our intention was to have that tree remain. And it is stated in the plan that the existing tree was going to remain.
All right, thank you for that. Okay, does anybody have any questions for Mr. Desain on this, Mr. Hindle? Yes.
Well, I would just ask the applicant, I'm just looking at the site plan that I have here. It just says existing deciduous tree. It doesn't say to remain. Is there a different plan I should be looking at?
Yeah, maybe there was another set of, maybe this is the first set of plan because there was a revision. I don't know, but it's supposed to read to remain. I'm not sure, but we have no intention to remove the trees because there's only 2 trees in this development and they're not in the way of the construction. So the forestry department of the city of Ottawa that requires a tree, an arborist, what do you call it, arborist report, requires that trees, the essence of arborist report is tree preservation. So we're preserving those trees, most especially because they're not in any way in the construction way. So it saves the owner of the property funds that, planting new trees. We're not going to remove them. So if it doesn't say then that's an omission, it should say to remain.
All right. Mr. Hernando, did you share that report with our staff, with Mr. Hodgins?
What report?
They just said you had somebody come in to look at the tree. Did you not? Did you not just say
I
that?
just
Maybe
said
I
that, no, I said the city requires that. We've not submitted it yet. We're just waiting to go through this process and we'll do the rest of, I'm saying that the city requires now an arborist report. I didn't say it is a
Right.
requirement which we have not fulfilled yet, but they fulfilled that. And I was saying that the intention of it is tree preservation. And we intend to preserve this most importantly because it's not in any way of the construction, proposed construction. And I remember, I think in the plan, it says existing tree to remain.
Okay, so have you read the staff report, Mr. Nandu?
Yes, I read the sent to me by Christine.
All right, so I'm going to point you to the additional comments part, number
Okay.
3. Number 3 says that staff note that the applicant that the minimum aisle width of the driveway is 2.6. Should the tree in the rear yard cause conflict with this provision, alterations to the site plan or the removal of the tree may be required. So I just want to signal to you that because we tie minor variances to plans, the choice really becomes limited. If the tree is in the way, then you either are back to see us again, or you're taking the tree down.
Okay. I will obey the conditions of the minor variance.
All right. Okay. Any other questions for Mr. Nandu, Mr. Hindle?
Maybe a question for Mr. Dessel. I think I take your point very well on parking and the issue that is rising in that neighborhood. Given, of course, that this application doesn't actually require it, what would you prefer to see when it comes to parking that would be different than what's proposed here?
Well, we have another property, not us, but on Marier, the property at 98 Marier, which is just a couple of doors down from us. And what he did, I'm not sure if it's a single or a duplex, like it's a 2 stories. So whether they have an apartment downstairs or not, or I don't know. But the parking in the front, providing them with a single dwelling means that one single parking will be sufficient and will work. I can't see, with my 30 years of experience on that property and what I have seen in the past with tenants telling me they have no parking,
Mr.
it's going to be continuous. Excuse me, am I speaking?
Yes, I was hearing somebody interrupt you. Thank you.
Yeah. So the parking, the increase in density that is proposed is creating a real issue and will be forever an issue. I think a single dwelling with a single parking in the front is probably what would be the best, is what I would suggest. And if you can take a look at the property at 98 Marier, I think they're very, very nice model. Thank you.
All right. Thank you very much, Mr. Dessel. Does anyone have any other questions for Mr. Dessel?
All right, I just had a bit of a follow-up. I noted at 108 Marier, there's 4 units there. How many parking spaces are provided in that front yard?
3.
3, okay.
3, and that has been a big issue to be short by 1. So I can't see somebody having 3 units with 0 parking. That, if it was to remove all the parking, I can't see it work.
Okay, Ms. Willis.
Just, Mr. Dessel, just your observation about the parking in the background is based on the current building, the current grading, and the current driveway. If they go through in submitting a building permit application, they have to do a grading plan. They probably have to do a tree report. They've got to make sure that the driveway and the parking spaces comply with the zoning bylaws. So if it turns out that by building the building and improving it such that it works better, do you have a concern about having 2 parking spaces in the backyard?
Well, I don't have a concern, but I can tell you, like I've looked at the space and they are going to be increasing by 40 centimeters. This is 40 centimeters. They're going to go from 2.17 to 2.6. This is not even 2 shoulders wide or 1 shoulder wide increase. It's going to be nearly impossible. Like, I don't have an issue with the parking in the back. That's not the issue. The issue is they're not going to go in the park in the back. They will park in the front. That's the issue.
Okay, all right, but we're not looking for a parking, I mean, parking is not actually part of the variances of this application.
I'm actually very surprised that a triplex in the city of Ottawa would allow no parking. Like,
yeah,
I don't understand. Like, it just doesn't make any sense to me.
Okay, well, then I would invite you to get involved in the review of the zoning bylaw the next time and provide your input. All right, definitely. Anybody else want to ask Mr. DeSalle questions? Mr. White.
Madam Chair, just a comment to follow up on my earlier comments about the parking. And I agree with Mr. DeSalle on the lack of a parking requirement for these types of development, but that's another issue. If the parking is not a required parking space, which I think in this case it is not, I mean, obviously it is not, you've heard that, then quite frankly, in my opinion, maybe I'm wrong, if parking is provided, it needs to comply, but if it's not required parking, technically, under the zoning bylaw, I don't believe it needs to comply with any of the dimension requirements that are mentioned in the additional comment 3. You're not providing a parking space that is required to be provided, so that if the choice is made to provide some kind of a parking space, it can be developed in whatever manner the property owner feels is appropriate, as long as he's not violating some other provision of the zoning bylaw.
So let me just respond to that, Ms. Willis, because I don't believe that to be true. I think that if they in fact decide to move forward with some development, that's what we're trying to control here. That parking space is development. If they choose to proceed with it, regardless of whether or not it's a requirement under the bylaw, it needs to meet, I think, the rest of the standards or seek to have a variance for it.
But it's not.
I see Ms. Willis, but I guess I stole Ms. Willis's thunder on that one. But yeah, so I don't quite see it the same way, and I guess we don't. So great. Any other questions for Mr. DeSalle? I've got to see if we've got anybody else out there, folks.
Madam Chair, could I get a comment from staff on that point about the not required parking?
So, Mr. Hodges, please tell us.
Through you, Madam Chair, I believe if it's being provided and used for parking, you would have to comply with the zoning bylaw requirements for the spaces and the aisles, as it would have to travel over the aisles to get to the parking.
All right.
Thank you, Madam Chair. I stand corrected.
That's okay. All right. So thank you, Mr. DeSalle. I think questions for you are done. I am going to move on to anyone else in the audience who or the public that would like to speak either for or against this application. Anyone? I'm looking for hands. If there's anybody. Okay. I'm not seeing anyone else. So we are now, I'm closing the public portion of this hearing on this application. So at this point, I need the members to tell me how you'd like to vote. Those for the application, support the application. Okay, Ms. Willis, Mr. Hindle. All right, those objecting to the application. All right, so the application fails. Okay, because there's 3 of us who are not in support of the application. So Mr. Anendu, your application is denied. I believe the reasons, and so we're going to need to provide, the decision will have the fullness of the reasons. But Mr. White, did you, for the record, want to give us your reasons for not supporting the application?
Thank you, Madam Chair. Yes, I'm in agreement with the concerns that were expressed by staff with respect to the lot width and lot area requirements. I just I'm not of the view that these are minor, notwithstanding the existence of historical development in the area that, quite frankly, as the gentleman from the neighborhood has expressed, has created some major issues elsewhere elsewhere in the neighborhood in terms of parking and other things. So I'm not satisfied that the general purpose and intent of the zoning bylaw is being maintained.
All right, thank you. Ms. Markovich, would you like to add to that?
Nothing to add. I mean, I would echo those comments. That is where I've struggled with this application as well.
All right, and I would like to add to that. I agree that it's not, doesn't meet the intent and purpose of the zoning bylaw. And I also would like to add that in my opinion, the application is also not minor. I believe that there's too many things. It's almost overcrowding, overbuilding on the site. So I'm going to suggest that it's also not minor. I think I'll articulate my reasons a little bit better in the decision, but that's essentially the notion or the concept I'm trying to convey. So Mr. Anendu, I regret to inform you the application is denied. So you may want to reach out to Mr. Hodgins and maybe reapply with a revised proposal. All right, thank you very much. Have a good evening.
Or appeal.
All right, next application, we're on number 3, and that will be 263 Greenway Avenue. And I am looking for Mr. Jacobs. Or, yes, Mr. Jacobs, come forward. Mr. Jacobs, still don't see you. Good evening.
Good evening. Sorry about that. I got kicked off the screen there for a moment.
Oh, that's all right. No worries there at all. So Mr. Jacobs, we're going to request a brief presentation from you, but before that, I need to get a statutory declaration from you. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days prior to the hearing, and that the sign was at all times clearly visible and legible? Do you swear or affirm that to be true?
I do so swear.
All right, thank you very much, Mr. Jacobs. I will ask you to do a quick presentation, if you will, and then we'll go to questions.
All right, the coordinator has some slides that I'd like to use.
Yep, it just takes a moment.
All right, the application we're dealing with is an application to increase resident parking on the site by 35. There's an existing cap imposed by site-specific bylaw for 85 resident spaces. So we would be increasing by 35 to 120. The image you see on your screen is the location of the site. It's adjacent to Vanier Parkway with frontage on Greensway Avenue, and it's just off of Montreal Road. The street is a mixture of low-rise apartment buildings with some singles at the far western end towards the Rideau River. Next slide, please. This shows you the context as it exists today. It's essentially a surface parking lot that surrounds the building that's on the site, which is 267 Greensway. All of them are surface spaces, as you can see. I would note that the spaces that would be just to the north, which would be in the shadowed portion of this image, adjacent to the apartment building, is where we're proposing to place the new 5 spaces that would be on the surface. So just for context, those areas, all of the areas that will be used when this land is developed are currently used for parking at the present time. We could go to the next slide. This is just a reference slide to show the development by my client and the ownership. 263 Greensway on the right side is the property that's under development. They also own 29 Mark Avenue, which is on the north side, which is 5 buildings, each containing 10, for a total of 50 units. On the south side, 20 Mark. At the far western end, there is a new development at 20 Mark that is currently under construction, containing 12 units. There is no parking provided on that site in accordance with the bylaw. The balance of 20 Mark is actually 6 buildings numbered 30 through 80, each contain 10 units, and on the which is 60 units. 267 is a 2-story apartment building that contains 9 units. Where we're proposing is a new 77-unit building. Next slide. This is the breakdown of the parking lot that currently exists. Parking capacity is 112 spaces. This parking lot currently serves 267 Greensway, as well as all of the adjacent Manor Park holdings. So if you live in any of the buildings along Mark Avenue, you are eligible to currently park in this surface parking lot. The proposed expansion we're requesting in this variance is an attempt to offset some of the loss of these spaces currently used by off-site residents. Next slide, please. While not part of this application specifically, this is the location of 20 Mark. It was, prior to its redevelopment, also a surface parking lot that provided service or spaces to the buildings located at 30, 40, 50, 60, 70, and 80 Mark Avenue. As I noted, there's a new 12-unit building that is going on that site. And as a result, in view of the zoning bylaw requirements for the 12-unit building does not require any additional parking. Next slide, please. This is a summary of the available resident parking and residential units on the site. In my written submission that you received, I indicated that the approved zoning permits an additional 46 spaces beyond what the bylaw would normally require on this site, and that those spaces were intended to serve off-site demands from other buildings in the area. Even with this represents an overall decrease in the historic parking supply of 88 spaces from the existing supply of 134 that you found on those 2 surface lots that I just described. The requested variance will increase the capacity on site by 35 spaces, but that's still a decrease of 53 spaces from the original supply, even though we're adding 89 new units, both at 263 Greensway and at 20 Mark. What you see in this table is that because there were some questions raised in the Vanier Community Association submission with respect to all of the available parking, my original submission only dealt with the 2 surface parking lots. So this summarizes all of the existing parking. So in the first column, the existing units, there's 119 at the present time. And the existing surface spaces, there's 174. After the development occurs, there will be, actually, there's an error on this chart in the column adjacent to 30 to 80 Mark. That number should be 60, not 50, so the third one down. So in total, there's 208 spaces, 208 units in this area. And the parking after the fact will be 60 in total on the surface and with 100 underground. So there's a decrease in capacity and a significant increase in the number of new units in this area. If we could go to the next slide. Just to orient you, on the west side of the slide is the corner of Greensway and Mark. The proposed development is in the center, and the Vanier Parkway is on the right side of the screen. The circled area are the 5 surface spaces that we would be adding, which requires a revision to the site plan. And a reminder that in this particular location, there were parking spaces prior to the proposed development. As I've indicated, the proposed site plan revision is subject to the approval by the city, and that would be filed pending the outcome of our minor variance application. If I could go to the next slide, please. This is a portion of the parking garage. The small inset plan in the upper right corner shows that portion of the garage. In that upper inset plan, you see 2 extensions of the garage going towards the top of the screen. Those are the proposed extensions of that first level of the parking garage to accommodate the cars. The 2 areas circled in green are tandem spaces. They are in behind other spaces. We tried to maximize the number of spaces we could put in, and the 2 spaces circled in red are spaces that have been added because of a change in the electrical supply to this building. There was to be a pad transformer in that location, but because it's being relocated, we're able to add 2 spaces. So we have definitely put in as many spaces as we can within the underground to minimize the impact on the surface. If I could go to the last slide. It's returning to the site plan we were looking at before. I just wanted to summarize the compliance with the 4 tests. The proposed variance is minor. While it doesn't result in an increase of 35 spaces from the required maximum of 85, all but 5 of these spaces are located in an area previously used for parking, and so there will be limited visual impact on the subject property or the building from the approved site plan and landscape plan. There will be no impacts on the adjacent properties, and in my professional opinion, the requested variance is minor and therefore meets this test. The general intended purpose of the official plan: the proposed redevelopment of the subject property has been previously approved through rezoning and site plan control. The requested variance is seeking more capacity in the underground garage to address a concern with respect to the overall decrease in local capacity resulting from the redevelopment of the surface parking lots. This capacity was being used by existing tenants of Manor Park Management, and there has been a desire on the part of Manor Park Management, the owners, to try to satisfy some of that demand with parking on this site. The rezoning bylaw recognized the fact that this parking would be for off-site uses, and that's specified in the zoning bylaw itself. So in my opinion, the plans this minor variance supports a redevelopment of an underutilized lot, which was a surface parking lot with compatible residential infill, and the development responds to. In my professional opinion, the requested variance does maintain the general intended purpose of the plan and therefore meets this test. With respect to the zoning bylaw, the parking requirements outlined in sections 102 and 103 of bylaw 2008-250 are minimum requirements. The intent of the requested variance is to provide additional resident spaces on the subject property that could be made available to residents of the building, the new building, as well as residents of 267 Greensway, which shares the property, as well as the residents of the adjacent on Mark Avenue. This will not be used for off-site long-term parking for people who do not already reside in the area. The overall result of the variance will not increase or even match the historic capacity for resident parking. At the same time, an additional 77 new units will be constructed on this site, and therefore, in my professional opinion, the requested variance does maintain the general intended purpose of the zoning bylaw as it applies to this property. The requested variance, is it desirable? The requested variance supports the redevelopment of an existing underutilized parking lot with a contemporary and compatible mid-rise building that has been approved through a zoning amendment. It will facilitate the reduction in demand for on-street parking caused by the loss of 134 parking spaces in the area, as well as putting these vehicles in an underground garage as opposed to on surface parking lots. The variance will have limited impact on the approved site plan and landscape plan or building design. And in my professional opinion, the requested variance is therefore desirable for appropriate development of the subject property and meets the test. Based on this analysis, it's my summary professional opinion that the variance for this proposed building is good planning and represents a desirable redevelopment of the site. I would also close by, should the committee approve this application, it is requested that the approval not be specifically tied to the plans and elevations filed. As noted, the site plan will require revision to allow for the 5 spaces shown on the surface. This may also impact some other elements of that site plan. So we need some flexibility to ensure that the city has an opportunity to review and make a decision on the site plan. As well, the elevations may change slightly as we move through the value engineering for construction and the building permit review. So again, while the project will not change significantly to be tied specifically to the exact plans that have been filed would be a hardship for the owner. With that, I'll conclude and turn it back to you.
All right, thank you very much, Mr. Jacobs. I just wanted to do, before we go to questions, I just want to correct the notice. It seems that we need to, and I think it's AdWords, but it's a residential 5th density. Hang on, bear with me. Residential 5th density B, but urban exception 2555 and schedule 395. And then it reads bracket R5B 2555 and then S395. So there's a long, obviously a long ending to that zone, but can you confirm that that's in fact a correction that we need to make?
Yes, I can confirm that.
All right, thank you very much. Okay, questions for Mr. Jacobs. Ms. All right, well, let's go Ms. Willis.
Mr. Jacobs, just wondering, with the recent rezoning and previous site plan approval of the process, was the issue of exceeding maximum parking requirements addressed at all as part of the zoning application, or was it not thought of at the time?
If I could, it was actually a very serious concern. The original submission that we made for this rezoning included a 2-level parking garage and significantly more spaces than we're proposing with this minor variance. In consultation with the community, there was a decision to provide a cap to that parking, resident parking, not the visitor parking, at 85 spaces. Subsequent to that, as the development has moved forward into the review and design and marketing of the building, there has been certainly a number of residents of the Mark Avenue buildings that have come forward asking what Manor Park Management is going to do to provide them parking. Some of the parking is actually included in their leases. And so as a result of that, Manor Park wanted to see if they could, without increasing the garage significantly, provide some additional spaces to address these concerns that have been raised with respect to the ongoing operations of their other buildings.
Sorry, just clarification. So at the time of the discussion on the zoning, there was general acceptance of the idea of 85 additional spaces, but it was not incorporated into the zoning bylaw?
Oh, yes, it's part of the site-specific schedule that 85 spaces was the maximum resident parking to be allowed on the site.
I see.
Other questions for Mr. Jacobs? Yes, Mr. White. Mr. White, you're on mute. Oh, sorry. You're on mute, Mr. White.
Jacobs, nice to see you again.
You too, Colin.
Just a question. Can you tell me what the ratio per unit would be in terms of parking? Are we looking at, 1.5 spaces per unit? What would any idea what the number would be total across the board?
With the minor variance in place?
Yes.
I think I did a calculation on that. So with 120 spaces and 77 units, it's a little bit more. It would be a little bit less than 1.5.
So yeah, we're in the ballpark of the old standard we used to use. Another question, the bylaw provision talks about parking lot may only be used by residents from a residential use building located on lots municipally known as 263 Greensway, 20 Mark Avenue, and 29 Mark Avenue, and that's very specifically identified in the in that Appendix C to the zoning bylaw that was implemented. How is that? I'm wondering how the city, and maybe this is a question I should ask the city, but how does the city intend to enforce that? Is there some kind of a registered agreement across all of the properties that acknowledges that parking is going to be available? I'm assuming these are separate parcels.
All right, so would you like an answer from Ms. Ramirez then? Yeah, okay, so Ms. Ramirez.
Through you, Madam Chair, the zoning was written so that a public commercial parking garage wouldn't be provided. I am not particular on how the city is going to enforce it. I'm not aware of how that's going to be done. I could find more information for you and get back to you, but I'd have to consult with the planner who was in charge of the site plan.
All right, so maybe Mr. Jacobs, can you shed any light on that then?
As far as city enforcement, I would have to agree it would be difficult to do so, but it's certainly the intent of the Manor Park management. The access to the parking garage itself is going to be gated and metered, so anyone getting in and out will require the approval of the owners and would need a pass. So they would be regulating who would be allowed into the parking garage, and they certainly have sufficient demand from their own tenants to ensure that the parking garage is full.
But there wouldn't be any formal agreement registered on title or anything like that?
That was not required, no.
Okay. Interesting. Thank you.
All right, thank you. Anyone else from the committee? Mr. Hindle.
Yeah, Mr. Jacobs, do you have any understanding or any knowledge of what the current, like how currently the parking is used? Is it fully utilized?
The small parking lot at 20 Mark, which has been replaced by the new 12-unit building, that parking lot historically was full all of the time. It was actively used by the residents on the south side of Mark Avenue. The larger parking lot where at 263 Greensway, it would depend on the time of day and what have you, but I would say it was at less than half capacity at most times.
Okay, so I assume that would have been taken into account when the cap was put on. Now, I'm very cognizant that this cap was placed through a more broad process than a committee of adjustment variance. So what really has changed in under 2 years for us to justify fairly substantially increasing that cap?
Well, I guess what has changed is what was expressed even during the rezoning process, that there was a demand that wasn't going to be met by the number of spaces within this garage. So there was a desire to on the part of the Manor Park management to relieve that or satisfy that demand by enlarging this parking lot in a manner that didn't affect the surface lot, because there is a desire not to push these people to park on the street. There certainly are sufficient cars, sufficient people wanting to use this parking lot of the residents that it would mean that you would be now filling up Mark Avenue with cars parked on the street, as opposed to in a more appropriate location in an underground parking garage. So it was partly to for their own benefit to ensure that Mark Avenue maintained its very picturesque look. It's a very beautiful street with 2 rows of nice walk-up apartments, and it's beautifully treed. To fill it up with cars when they could be parked for the most part in this parking garage seemed to be a better approach, and that really prompted this application for the minor variance.
Okay, but presumably that those considerations were taken into consideration when council put in a very explicit cap that may be kind of different and is very site specific in this case. So what you're effectively saying is that council got it wrong. Is that correct?
We made an estimate of the demand of parking at the 85, and it was insufficient. So I wouldn't say council got it wrong. I would say that we agreed on a number that was too low.
Okay.
Madam Chair, if I could just comment, it's clearly City Council's reviewed their original decision when they had to make a special provision to allow this application to come ahead for our review. So there's been some, I would suggest there's probably been some rethinking at the City Council with respect to these parking requirements, because of they've taken the initiative to bring this on earlier than might normally be permitted by the process.
Thank you for that. Ms. Markovich, I saw that your hand was up as well.
Yes, thank you, Madam Chair. I just want to make sure, again, building on that discussion, that I understand you. The request, the increase in parking spaces that you're requesting is to accommodate demand, not from the subject property, not additional demand from the subject property, but from anticipated demand through other properties in the immediate area. Is that correct? Or is this demand that you're trying to accommodate through this proposal from the actual subject property? Just want to make sure I understand that, where the demand is coming from and that changed.
It will be a combination of those things. Certainly, people on site will be provided with people that reside either at 267 or at the new building, 263 Greensway, will be given the first option to use these spaces. But there will certainly be additional spaces beyond that that will be made available to those that lost their spaces as a result of the redevelopment.
And do you happen to have an estimate of the proportion of that? What's the proportional mix of that demand in your analysis?
I do not have that information.
All right. Thank you. Mr. Hindle, saw that you had a follow-on question?
Yeah, sorry. I just wanted to pull from Mr. White's comments. When you made the application to council to effectively allow you to make this application, was there any discussion at that point of the substance of the application, or was it just a straight, we would like to make an application generally, please allow us to do that?
City Council, through the Councillor Fleury, who's the councillor in the ward, was fully aware of the number of spaces we were requesting and the reason we were requesting.
Okay.
Okay. Ms. Willis.
Sorry, just following on from the same question. I'm just wondering if you can fill us in a little bit more about the nature of the discussion. Was there discussion at council about you know, I see that there's a need for parking. I see that there's restrictions on the street on Mark Avenue for 1 hour maximum parking, probably as a result of a reaction to people parking on the street because of a shortage of parking. but I don't have an understanding as to what the discussion was about putting the cap on in the first place, and then further about relieving or giving relief so that you can come forward to the committee to seek a variance. Was there any discussion that we're missing? Maybe staff can address that question as to whether or not there has been discussion that would specifically, I guess, impact our decision on whether or not this is appropriate in terms of the lifting of the 85 cap.
I think it's Ms. Ramirez.
Through you, Madam Chair, I believe the original number was related to how many dwelling units would be on 263. So there was 9 and then 77. So works out to be 86 dwelling units. So it would have been almost a 1-to-1 ratio for parking. And the exception was written to take into to allow parking of the Mark Avenue residences, and it was capped to give a little bit more certainty and to limit the amount of the impact on the landscaping.
So the number of spaces that were being allocated to other apartments within the stable of the developers' buildings was used. It was already included in that 85 cap, or were they not included in the 85 cap?
I believe that the rationale around it was that it was the 85 corresponded more or less to a 1-to-1 ratio for the existing dwelling units on site. And the reason to cap it was that it could add some certainty to how many leftover could be rented out to the residents of Mark Avenue. And with the development, there has been residents, as I understand it, have expressed concerns regarding parking, and the detailed design show that there is the ability to accommodate up to 35 spaces. And so that's why the council passed a motion so that only the parking could be varied and up to 30, or yeah, only the parking could be varied.
Okay.
So at the time, Mr. Jacobs, at the time of the rezoning application, I'm just a bit confused about whether or not, knowing that parking spaces were being leased to other tenants elsewhere, whether or not they were being left out even then, or is this something that's happened since the original zoning application?
The number of spaces involved wasn't clearly known at the time of the application, and that information has come forward to the owners as development started to take place, particularly at 20 Mark, and that parking lot disappeared of those 22 spaces. So while tenants were aware of the rezoning and the potential redevelopment, I'm not sure that it sunk in that these things were going to disappear, particularly the 20 Mark, as quickly as it did. So that reality has resulted in more people coming forward and wondering how they're going to deal with the parking of their cars. So certainly it was a very contentious issue, and there was a lots of discussion of it at the time. The concern was more about it being used as a commercial parking lot due to the scale of a two-story parking garage at the time.
Mm-hmm.
It was made quite clear that this was never going to be a commercial parking lot. It was always going to be just for residents and tenants of the community, that or residents of the buildings owned by Manor Park Management. And they have been owners for a long period of time, so there's certainly their record of activity in the area is well known. So I think it's a significant improvement to move cars that could potentially be parked on the street underground. This development is also resulting in an extension of a required multi-use pathway across the property. That land was dedicated to the city to allow for a bicycle and pedestrian connection through the property, which was not envisaged at the beginning of this application process. So it's not that this development is car-centric or trying to be satisfying just auto drivers. There is a strong desire to support alternative transportation methods, and there's a significant degree of bicycle parking storage and other things that could have been removed because it's in excess of the bylaw requirements in the garage, and more space is put in down there. So we are trying to reach a balance, and we understand the community's concerns about this, but there is definitely a demand for parking spaces that we feel can be better addressed by allowing this minor variance. And as Mr. White pointed out, City Council was aware of that in their deliberations in allowing us to make the application in the first place.
Thank you.
All right, thank you. Ms. Markovich?
Yes, thank you, Madam Chair. You mentioned, so with the one-to-one, I guess, parking ratio that Ms. Ramirez referred to earlier, so then assumes of the 77 rental units as part of this new development, you're assuming 1 car per unit. Is that, do you have anything in this development that is going to somehow mandate that? I'm wondering, of the 77 units, are they all 1 bedrooms? Are they some of them 2 bedrooms? Do you have that sort of information you could share with us?
It's a mixture of 1, 2, and 3 bedroom units. So there is quite a wide variety of unit types in the building. I don't have the breakdown in front of me at the moment, but it's certainly intended to be a wide range of units serving broader family household needs.
So with that in mind, the 77 units could generate certainly more than 77 vehicles.
Well, I can't speak to that. Certainly that's a possibility. There are certainly people that are looking to live in this area that don't drive cars. These would be new residents moving in. I think the gentleman on one of the previous applications was convinced that even a 3-unit building required a parking lot. So, I mean, there are certainly both sides of the coin in when you're looking at marketing an apartment building. The experience of Manor Park Management, who have been landlords in Ottawa since the 1980s. They are very familiar with what they need to market the property, and they're comfortable with the variance to increase the parking lot to 35, that they would be able to satisfy both their off-site and on-site needs.
Okay, thank you.
All right, Mr. Hindle.
Mr. Jacobs, if there's such a concern about parking related to this area and this development writ large, why did your client very recently undertake to develop the parking lot and remove 22 spaces on 20 Mark Avenue?
In keeping with the policies of the official plan, it was a parking area. It was an underutilized area that could be redeveloped using the city's policies for intensification and infill. The parking there was deemed to be unnecessary to serve the needs of that particular building, but as a result of the much larger parking lot at 263 Greensway, 112 spaces, the loss of that parking lot is a problem for some of the existing tenants in the older buildings. So my client is trying to implement the policies of the city's official plan with respect to intensification and reusing properties and making better use of lands that are in close proximity to transit and cycling and a variety of things. But there is still a need for parking cars for some of the residents of those buildings. So this is seen as a compromise that, in my opinion, satisfies the intent of the city's official plan with respect to redevelopment and intensification, and also means of satisfying alternative transportation needs, the car being one of them, as well as cycling and pedestrian and transit in the neighborhood.
Right. So in this case, when council would have made its decision, it would have made its decision assuming that those 22 spaces on 20 Mark were in existence. So given that you've removed those, it's really an addition of 13 spaces plus the replacement of those 22 spaces that have been removed. Does that logic kind of make sense?
You could do the math that way, yes. I mean, you have to look at the loss of the 112 spaces by virtue of the redevelopment of 263 Greensway as part of that equation.
Right. Yeah, and I certainly do take your point as to the encouraging intensification and very much making use of these underutilized sites. And I certainly appreciate at the very least that this additional parking is for the most part entirely underground, so that there's not the same visual impact at the very least. So I do take that into account as well.
All right. Any other questions for Mr. Jacobs before we go to a speaker? All right. Thank you. That was a lot of information. So thank you very much for those questions and the answers, Mr. Jacobs. So I'm looking for, at this time, I am looking for Ms. Lepine. Ms. Lepine?
Oui, bonsoir.
Oui, bonsoir, Ms. Lepine. Voulez-vous parler en français ou en anglais? C'est comme vous voulez.
Merci, je vais parler en anglais. Oui, ça va. I would like to thank the chair and the committees to give me the permission to speak. I'm a board member of the VCA, and also I'm a resident of Kingsview Park. The committee welcomes the development of 263 with the following caveats. The Vanier Association opposed the approval of the application to grant a minor variance to permit an increase of parking. It would represent a 41% increase. A parking ratio of 1:1 for the 85 parking space has been approved. We've discussed this intensely. Actually, this city planners commented that the purpose of limiting parking to a maximum of 85 space was to ensure that the balance of site remain landscape and to control the amount of parking that could be leased by the Mark Avenue apartment. So there was an original submission that was dated June 5th, and it said, this was submitted by the developer, it says that all additional parking spaces will be located underground. Now we receive a revised plan, August 18, that says there was going to be an additional request for 5 parking space at grade level and 35 underground. I have to say that the 30 we saw in the design, the first surface parking is abutting basement apartments. There are people living down there. The spot also should not replace a green space. This is an area that there's very little green space left. There's no green space left if the 5 parking lots are going to be there. The approved landscape plan indicates that the trees are being planted over the proposed extended underground garage on the south side. So this will greatly jeopardize these trees as well. Kingsview Park resident, we continue to express concerns regarding the increased number of parking space. Kingsview Park also has only 1 exit and entry to the neighborhood, which means it's putting a lot of stress, a lot of traffic on Mark Avenue, North River Road. Also, we find that consideration must be given to a busy and renovated Montreal Road and North River Road intersection. It's all under revitalization, and it's going to be even slower to go of the building, community of the neighborhood. On a daily basis, we have thousands of users, pedestrian and cyclists, who cross this intersection. We have NCC, MUP just beside it. So there's a lot of bottleneck created at this intersection. So we want a traffic study that was, well, the traffic study was done in February of 2018. So we would like to have another traffic study that would be done during the month of May and September, which would be more representative of what the congestion is around that intersection. Also, the momentum reports indicate that we're talking about these extra parking to a space for Mark Avenue, the 11 building on Mark Avenue. These are zone R4, and R4, there's no requirement according to the bylaw to provide parking space. And I want to note that there's already existing 55 parking space in for the 11 building on Mark Avenue. These spaces are behind the building and beside the building. So these parking spots should be accounted for. There is no evidence that tenants have expressed a need for additional parking as stated by staff report. Even with the construction of 20 Mark, which is underway, the existing surface behind the parking lot behind 267 is only a quarter occupied. We saw in the picture, I've lived here for more than 25 years and I often go in that area because there's another MUP, and that parking lot behind 267 is, if occupied, a quarter occupancy. It's not well occupied at all. Concerns remains among residents that the intention would be to conduct commercial parking operation despite the bylaw. I have to say that the developer owns 2 other properties very near this proposal. Just across the street from Montreal Road, he owns 2 properties with a total of 9. It could potentially become a 937 parking spot. So we need to make sure that the proposed increase of parking is not intended to accommodate other owned buildings and provide parking for government and public building in the same area. The Vanier Community Association recommends to the Committee of Adjustment that minor variance for increase of parking be rejected in favor of the official plan, the new official plan, the City Climate Change Emergency Policy, the revised Master Transportation Plan. The proposed additional parking spaces represent, we think, car-centric development, which is not consistent with the city's own policy outlined in these documents above. These plans support a reduction of car dependency while promoting sustainable active transportation. So in conclusion, we submit that contrary to the planner's opinion, the 4 tests have not been met. The proposed variance is minor. All the additional space will be located in the underground parking garage, so there will be no visual impact on the subject property or building from the approval, site plan, and landscape. There will be no impact on the adjacent property. That's not true. There will be. They will affect the site plan and the landscape. The general intent and purpose of the official plan is maintained. Not true. I've previously explained. And the request variance is desirable for the appropriate development of the property. It is our opinion that the rejection of the variance will not affect the desirable development of the property. So, thank you.
Merci, Madame Le Pen. Questions, Mr. Hindle, are you raising your hand?
Yes, I just have a question, I think, to staff related from some of the comments. This variance, if it were to be approved, would it just change, in this case, the urban exception to 555 to be 120 in lieu of 85, but keep in place the restriction that the parking would be only limited to residents of 263, 20 Mark, and 29 Mark?
Through you, Madam Chair, it would provide a variance to that provision that the maximum allowable parking would be 85. It would then be varied to 120. The other provisions would not be changed.
Okay. So okay, thank you.
All right, other questions, Madame Le Pen? All right. I don't have anybody else on my speakers list, but I'd like to give a chance to anybody who would like to come forward at this time to speak either for or against the application. I have somebody who's raised their hand. Would you like to come forward? I see Linda Fish. I'm sorry, I don't, I'm thinking. Would you like to come forward? Ms. Papworth, did we lose the person?
Can you hear me?
Yes, we can hear you.
Okay.
Can I have your name and
Yes,
your
sorry.
municipal address for the record, please?
Yes, my name is Linda Fish, and that's Lynda Fish, like poisson en anglais.
OK. Puis votre adresse?
30 Mark Avenue.
OK. OK.
I'm a tenant on this street for about approximately 20 years. And I was just wondering if the owners of this street would consider doing a formal survey to inquire towards there are a lot of tenants here. There are some that are very have been here a long time, over 30 years, and then it's kind of a rotation of a lot of people that come and go every 2-3 years. So it's I know a lot of the neighbors, and I've been wondering, Mr. Jacobs talked about, I may have misunderstood. I thought he said that Manor Park owned these buildings since 1980, but that's not possible because they purchased them only about several years ago. But anyway, the point is that would they consider doing a formal survey towards the the tenants, because I'm not convinced that all tenants are requiring or requesting parking down the street. For me, for example, it would mean a walk all the way down and to go to a parking lot underground. And I do, when the pandemic will be over, I do go out evenings. I do go to the theater or whatever, but I also I come home sometimes late, and I would not want to walk alone all the way to my building. So I do have parking, so it's not myself, but I know that I've spoken to some of the other tenants, and many of them park on the street. Some have bought city parking now, and I'm just curious, or I feel that there should be a survey, a formal survey, to establish if there really is a need for more parking.
All right, so Mrs. Fish, I can ask the question. It certainly is not jurisdiction that this committee has at all, and neither is it something that is typical of any processes under which for the committee of adjustment to consider. So it's not something that we typically can really deal with. That said, I'm open to asking Mr. Jacobs if, and I think what the resident is really asking Mr. Jacobs is, how are you going to operationalize that? So how have you, so to Mrs. Fish's point, how do you know that in fact you're going to get the use from people in other buildings, given the distance perhaps?
Well, certainly it's the experience of the current property managers, Manor Park Management, that they will have no difficulty filling the spaces with existing residents. Yes, with respect to 30 Mark, it is a fair walk to get down to this building, but the parking that is currently available to the residents in 267 Greensway, as well as 70 and 80 Mark, in particular 80 Mark, it currently has 6 parking spots along its eastern side that will be lost as a result of this development. And there are people in that building, 80 Mark, 70 Mark, as well as 267, who actively use the existing parking lot that is being built that this 263 Greensway is redeveloping. So the company is confident that these spaces will be made use of by the existing residents within close walking distance. The speaker mentioned that the owners didn't own these particular properties since the 80s. That's correct. They bought it about 7 or 8 years ago. However, as far as landlords in the Ottawa area, they've owned Manor Park Estate for at least 30 years. So it's they have a long history of renting apartments, townhouses in many buildings throughout Ottawa, and they're very familiar with the demands of marketing new and older buildings.
We've lost.
Looks like we have lost our chair.
I know. That's what I was thinking. She stepped out.
So maybe we'll hold for a minute or two just to see if her technical difficulties are short-lived. Otherwise, we will continue on. So currently it's 8:55. Maybe let's give her to 8:57, and then if she does not return by then, we'll take back.
Okay.
All right, so seeing 8:57 come up on my calendar, or my clock at the very least, why don't we resume? Hopefully our chair will return, but she may be barred from voting on this application specifically if she hasn't been able to hear all the presentations before her. So with that, maybe I'll ask members of the committee if there's any other questions for Ms. Fish. No? Okay, seeing none, I'll then open up the floor to any other participants who would like to say anything this evening. All right, and seeing none, I think then we'll be able to close the public hearing portion of, oh, there we are. So it looks like our chair is in the midst of returning. So welcome back.
Thank you. Sorry for that, folks. And I swear I do pay my bill for internet. So, so sorry about that. So have we concluded the line of questions, or just catch me up here?
Yeah, so we've concluded the line of questioning. We stood down for a minute to see if we could get you back right away, but you haven't missed anything. But we have kept it open for any other participants, and we've seen none. So we're ready, I think, to move forward past that.
All right, thank you. Okay, well, committee then, I think at this point, I just want to make sure we've run through everything else that we need to do on this application. All right, no, I don't see anything. I think it's time for a decision, folks. So, Ms. Willis.
I'm just a bit confused about something. Again, I'm wondering whether or not we could put up the template there, the table that showed the parking underground and above ground, and it was part of the earlier presentation.
Ms. Pepworth?
Okay. So what I'm trying to figure out, it says that in the staff report that we're the total number of parking spaces going from 85 to 120, not including visitor parking. So is there visitor parking in addition to the 120 spaces that are being proposed? Mr. Jacobs, I guess. should-
Yeah, if that question is to me, there are 7 visitor spaces on the surface.
So the 120 will be mentioned in the exception, as you said later, but the 7 is not included at all in that formula. That's something that site plan control would look at. Is that correct?
That's correct. The cap relates only to resident spaces, not visitor spaces.
And are 7 spaces what are required for this number of units?
Sorry, I got lost in a bit of a shuffle there. What was the question?
The 7 visitor parking spaces, is that a bylaw requirement?
Yes.
Okay, thank you.
Okay, we're ready to go to a vote, folks? Those in favor of the application? Hands?
I'm
All right, Ms. Markovich? Not in favor?
No, I'm not in favor.
All right, okay. I have to admit, this is a hard one for me. I was a bit on the fence for this one, but I think all told, I know what the worries are for the public about a lot of government buildings being nearby and a demand for parking and that kind of thing. But I don't know that we'll see that kind of demand going forward again. So just based on the way work has changed. So on that basis, I'm going to support the application. So for the record, so I think that's it, Mr. Jacobs. I guess the next step for you is to submit a revised site plan and move forward with your application as is. Is that correct?
That's correct, Madam Chair. I appreciate the committee's support for the application, and we will proceed to file a revised site plan with the City Planning Department.
All right. Well, thank you very much, and good luck with the project. Okay.
Madam Chair, I have a question.
Yes, Ms. Ramirez.
The applicant had asked to have a bit of flexibility in terms of the location of the parking, and I just wanted to confirm that that flexibility was going to be granted so that the plans could be further refined through the site plan control process.
I'm okay with that. Members, you're okay with that as well? Yes. Okay, so we're going to allow that, Ms. Ramirez, and in fact, it might be to hopefully to improve even on the configuration that's being proposed based on some of Ms. Lepine's comments. Maybe there was some room for improvement, so we'll certainly support that. All right, thank you very much, Mr. Jacobs. Our next application for the evening is number 4, which is for 58 Rothwell Drive. And I'm looking for that one. Is there an agent, Mr. Rutherford? We have Mr. Rutherford.
Mute.
So is it Mr. Rutherford? That's the agent? Are you the agent? That's who we're looking for.
I'm acting on behalf of Mr. Rutherford at the same where I work at the same firm. I'm Paul Kershaw.
Okay, all right. So, thank you. That's, so we do have a speakers list and Mr. Rutherford's name was submitted to us. So, okay. So Mr. Kershaw is
Yes.
who, all right. So Mr. Kershaw, we're going to want a brief presentation from you on the proposal, if you would, please. Oh, and statutory declaration.
Aha.
Yes. So
The last one of the night.
Yeah. No, actually,
Oh,
it's
no.
not. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies? Secondly, for the prescribed number of days before the hearing, and thirdly, that the sign was at all times legible and clearly visible. Do you swear that or affirm that to be true?
I affirm that.
All right, thank you. So I'm going to ask for just a brief presentation from you, if you could, please.
Sure. Bear with me. This is my first time doing this, so I'm a little nervous, but I wonder, there's a slideshow presentation. Thank you. Good evening, Madam Chair and members of the committee. We're the acting agents on behalf of the owners at 58 Rothwell Drive for the minor variance. Just going to give you a bit of context of the site. The site is a fairly large interior lot located in Rothwell Heights. The neighborhood is characterized with large, well-treed natural lots with single-family homes comprising of 1- and 2-story homes. There's a mixture of older homes as well as significant amount of new custom builds within the area. Next slide, please. The proposal is to demolish the existing 2-story home with a rooftop terrace and develop a new single-family bungalow with a peaked roof and attached garage, which will be the new owner's home. The house is surrounded by natural vegetation the house is surrounded by natural vegetation. Along the north property line are extremely large hedges providing privacy to the neighboring 54 Rothwell. Along the south property line, there are large coniferous trees also providing privacy to the neighbor at 62 Rothwell. The reduction these trees and hedges are to be maintained over the course of construction as well as an additional measure. The reduction of the 2-story house proposed to the proposed 1-story will increase the privacy to the neighbors and will allow for more sunlight to flow into the neighbor's property. In addition, the proposed bungalow is further away from the south property line than the original house. The proposed house will also have large windows located in the front and rear with smaller windows along the side. Most of the side windows, if not at all, will be covered, if at all, will be covered as they are bedrooms and bathrooms. To achieve the new proposed home, we are looking for 4 variances to the bylaw, in which we'll go through and explain that and discuss them each one. Next slide, please. The first variance is the side yard combined setback for lots greater than 36 meters to reduce to 19.78% for a lot width of 8.13 meters from the required 40% to allow for a maximum building width of 32.97 meters. On the one side, the minimum 3 meters, on one side being 3 meters and on the other side being 5.13 meters to equal the 8.13. It will be an increase of over 1 meter further away from the previous southerly neighbor. We would like to point out that Mrs. Ramirez's report, she points out that there are changes in the forthcoming bylaw concerning the reduction as the total side yard setback is quite onerous. If this provision was enacted, we meet and exceed the total setback, which would require a 7.25 meters, which we will be providing 8.13. This same issue was also tabled in past weeks ago for 18 Oriole in Rothwell Heights, which is a much larger and 2-story building. This proves that this meets the further bylaw amendments if it is granted. Next slide, please. The second variance is the front facade articulation. We are requesting to reduce the additional building envelope setback from the required 2 meters to 1.22 from the main building front facade line. This requirement is intended to apply to large homes on large lots in the outer urban areas and is extended and is intended to add articulation of the building facade of wide homes to break up the mass of the building. The projection of the garage in front of the building, similar to others in the neighborhood, such as 34 and 54 Rothwell Drives, adds articulation to the front facade building and breaks up the flatness of the building that represents about 20% of the building width. As you can see by the chart here, the difference between 1.2 and there's a difference between 1.2 and oh, next slide. Sorry. Yeah, that's right. We're there. Sorry. We are providing additional articulation across the front ranging from 1.2 to 3.5, which represents 64% of the building's width. As you can see from the front, and next slide. As you can see from the front elevation, the chosen materials also add articulation to the front facade. Next one. The third variance is to permit an attached garage to be located closer to the front lot line than the front wall of the principal building. This requirement is intended to ensure that dwelling's facade and the front door are the most predominant than the garage. The proposed garage has been orientated so that the narrow depth of the garage is facing the street and the overhead doors are facing the southerly lot line. This results in less garage width in the front facade. Next slide, please. This happens on several neighboring houses, as referred to as label G in this slide. There are at least 8 houses with garages that are in front of the main facade in close proximity to our house, and both direct neighbors beside us are also have this condition. Next slide. Notice that the front facade, that the garage facade doors are not visible, and the only visible from the side in which the amount of pure mature vegetation on the property will not affect the neighboring properties. The impacts of this garage location will be minimal and will negatively impact the streetscape of the surrounding properties. Next slide, please. Oh, and the next one, sorry. Yeah. The final variance is to permit a driveway to be located between the front wall of the proposed house and the street. Due to the fact that the proposed garage faces the south lot line, the driveway is necessary to extend in the front of the front facade. Next slide, please. This area will allow for the backing out of cars out of the garage only, with the garage being located approximately 36 meters back from the front property line. And with the amount of soft landscaping dominating the front yard, as well as the existing large trees remaining, will screen the dwelling from the street, thereby minimizing the visual impact of the streetscape. Note that the 4 other properties on Rothwell Drive also, of note, 4 other properties on Rothwell Drive also had circular driveways. To conclude, the proposal meets the intent of the official plan. The dwelling is permitted and is a desirable use for the area. The proposed dwelling will retain as much a natural vegetation as possible to maintain the current level of streetscape and privacy for the neighbors. Therefore, in our opinion, along with Ms. Ramirez from the City Planning Department, that the variances meet the 4 tests under the Planning Act and are good land use planning. If you'd like to view the next slides, it's that's the side yard hedges on the left side, or the north property line. If you keep going, it's just looking down. That's looking down closer to the house. It's just extra stuff. Continue. This is from the rooftop patio looking at 54 Rothwell. So yeah, that's fine. And that's it.
All right, well, thank you very much, Mr. Yes, Mr. Kershaw, you did very well, so thank you.
I thought I was a little fast.
No, that's all right, that's all right. So I'm gonna give the committee an opportunity to ask you some questions. So sure. Right. You're on mute, Mr. White.
Thank you, Madam Chair. Mr. Kershaw, am I correct in saying that the proposed new development will have, from what I can see, no impact on the periphery landscaping that already exists? I think those photos that you showed indicate that landscaping. I'm looking at the site plan that was submitted showing existing and proposed development, and it would appear to me that there's no impact on any of the peripheral landscaping features. Is that correct?
That's correct. Along the both property lines, along both side property lines, we're retaining all of the natural vegetation. As you will see, there's about 4 or 5 interior trees that are currently on the northerly side, right by the pool, that would be deleted, or because that's where the house is. But the side lot lines, nothing's being touched.
And we're going from essentially a 2-story to a primarily bungalow.
That's correct.
Type of development. Thank you.
You're welcome.
All right. Thank you, Mr. White. Anyone else? Okay, I don't see any other questions. So with that, then we do have a number of speakers for this application. Let's see, who have I got? We've got, I'm going to start with James and Patricia Paul. Hello. Now you're on mute.
It's okay.
Okay, let's try that again.
Now?
We can, but we're hearing either static or something. So can you maybe turn the sound down maybe a little bit? I don't know whether it's up or down, but.
We have you turn to the maximum, Madam Chair, but I can turn your audio down just so that we can hear you. Now, does that make a difference on our?
Okay, so we're still hearing a lot of, it's not interference, it just is definitely not clear and okay.
To be clear, so we can play on the
Mr. Paul,
does that help?
Mr. Paul, we can't make out what you're saying. So can you, is there a way to, it's almost too loud. I'm wondering whether or not by reducing the volume.
I'm seeing if turn down the microphone.
Okay, so we're not hearing you. We can't make out what you're saying.
I'm going to see if we can adjust the microphone. It's picking up, so maybe the coordinator could instruct us on, because this is your app that we're using, right? So I'm going to see.
I'm not making out what you're saying. Is anybody else having trouble hearing what's being said? Yeah, okay. It's not just me. So,
can you hear us now?
Barely.
Asking if the coordinator can tell us where the microphone adjustments would be on this app.
I'm sorry, I can't even make out. I think you've asked a question, but I can't actually make it out.
I think he said he wants the coordinator to tell him where the microphone adjustments should be in the app. But as a backstop, is there a route for him to call in just by phone? I think there is with this.
There is, as a matter of fact.
Just as in case this cannot get resolved. I think it might be an issue with the microphone, but I don't know
now,
specifically how it could.
I have found the microphone settings. Does that
Well, that's much better.
Much better.
Yes, you are good. You're fine now, Mr. Paul. So please start again.
Okay, sorry. So can you hear us clearly now?
Yes, absolutely.
Okay, yeah. So that was when I found the microphone settings down below and the microphone was turned to max on this app, not on our computer, I was able to turn it down. Just if that helps you with a future person. So anyway, thank you very much for allowing Patricia and I to make some comments here. Can I assume that the committee would have read our letter that we
Yes.
sent to the committee?
Yes, we do. We do read
Okay,
them.
thank you. So I won't then read the whole letter, but I'll just point out that we only had 4 comments that we were making. I want to start off by saying, that we are favorable to development on the lot, just to be clear that we're not suggesting there shouldn't be development. Initially, there were 2 pretty important errors we felt we wanted to point out to the committee. I'm looking, we have extensive documentation we received in full-size plans. So, first is that on the chart that speaks to the variances, it does say no side lot was less than 5 meters. So as you know, the request is to have a minor variance to reduce the lot on our north side setback to 3 meters. So that's important to us, because if the city planners read the same thing we did, saying there was no setback less than 5, when in fact we could only, by using a ruler to scale, ascertain that it was 3. So that was error number 1. Error number 2, and I just heard the planner present. I'm surprised because we met Monday evening with the owner and went over our concerns with him and actually sent him those in writing, but he never responded prior to this call. But so physically on the property, we confirmed with the owner that in fact the cedar hedge that the planner has just referred to as providing privacy actually ends in line with our home. So I don't know if the coordinator can bring up the initial drawing that shows the existing home, because I'd like to make 2 or 3 quick references to that. But so for example, the planner has said how, there's no privacy issue or impact, and yet the entirety of the new house, other than the garage, which is a significantly larger structure, is situated past the location of where the hedge ends. So beyond the cedar hedge, which from the roadway to the corner of our house is a large hedge.
Sorry, Mr. Paul, I'm just going to interrupt you. Ms. Papworth, I think we're looking at the next application on this. Sorry, go ahead. I'm sure we'll get the right plan coming up in just a minute. So go ahead, continue, please.
Thank you, Chair. So as I said, we'll see when it comes up. That was the second error. We just wanted to point out that the drawing is actually incorrect. The cedar hedge ends at the back corner of our house. And what is along the property line from that point forward, which is important because it's the entirety of where the new very large home structure will be. There's actually 6 large maple and birch trees that are not shown on the drawing on the property line. And then in between them, there's some deciduous bushes. So yeah, so this was, I was hoping to get the site plan drawing. This is the aerial photo, but I could refer to this unless the coordinator can bring up. Yeah, so this is the new proposed structure. And there's also the drawing that shows the existing. So we have a single page that shows the 2 of them side by side, because I'd like to make a couple other references if I could. But if the committee could look, so on the left or north side, you see the end of our bungalow. And if you were to draw a straight line from the back corner, that's where the cedar hedge in fact ends. It does not go beyond that. So the reason this is important, because the application does refer, and I just heard the planner speak to the privacy that's permitted. So I want to say this, although this is, there's a 2-story structure there now, and the new structure as proposed is a bungalow. If you look at the height, the height of the new structure is within 1 meter of the existing 2-story. I also want to point out, and again, this is where I wish we had the other drawing that I was, and if the coordinator can't get that, I would prefer to go back to at least the aerial photo. So, okay, so this is the proposed again. So, so maybe the aerial photo would be the one to refer to. But just to say that on the current structure, there is so yeah, let's stay with this. So if you look at the area to the north, the left area with the brown roof deck area, that is a 1-story, 2-car garage with a flat roof. So the actual 2-story structure that they're referring to is 20 meters from the existing lot line. The fact that the proposed bungalow is virtually the same height is pushed from 20 meters to 3 meters of our property line. And because of the larger mass of it, and it also pushes backwards. And I can tell you, I did a rough calculation using a scale ruler on the drawing. So there is a 50% of the proposed structure now comes within the 3 meters and then rear of our home. So it's a substantial increase in mass right against the property line. So when you look at the height of the structure, so yes, it's no higher than the existing 2-story, but when you move a building of that height from 20 meters from the lot line to 3 and ask for a minor variance like this, which in our mind is not minor, given the mass of this building and pushed back in footprint. So again, I mentioned to you that you can see from the aerial photo the cedar hedge where it's ending, and then you go into these deciduous trees. So of course, we all know in Ottawa, whether it's 7-8 months of the year, there's no leaves there, they're deciduous. It represents a substantial loss of privacy to the rear of our property and on that south-facing end is the main living area. Like our north end is where our garage is located. So the living part of the house is to the south. Also, in terms of, I made a note when the planner claimed that there would not be a loss of sunlight. Well, we have a structure that's as high as the existing building, pushed to within 3 meters of the lot line. So in fact, there will be a substantial loss of the morning sun, because with that exposure, that's where the morning east sun comes in. So we will have a loss of privacy, a loss of sunlight, increased noise with the rear porch and area of the home being in such close proximity to the lot line and behind our home, and a resulting loss of enjoyment of our property. So that's my main statement, just to say our concerns. And in my letter, as you saw, we proposed something that is still would require variance, but we thought would make it at least a little more less intrusive to our current building arrangement. So it was simply to require that the setback be 5 meters on our side, just as it's going to be 5 meters on the other side. That represents less than a 5% change in the width of the home, but to go from 3 meters to 5 is significant when it's being pushed this close to our lot line of a building of this size. We're very concerned that only 3 meters from the lot line to excavate for this building, whether in fact, there will be an impact on the hedges and trees that even the applicant is saying they're relying on, that we don't have to worry about the mass of this and the location and everything, because we've got all of this privacy. We're suggesting it's much more limited privacy than has been submitted. But also, what if it doesn't survive the excavation in that proximity? So the other point, and maybe could I ask the coordinator if they could go to the north elevation of in the drawings? One more, please. Oh, sorry. So back in, yes. So if you look, you were there. Sorry, if you could just go back. Yeah, on the bottom then is the north elevation. So this is what is presented to our facing our side of the property, right? So I just want to point out a few things. So because of this goes into my final comments about the garage. So we're faced with a building now between the porch, house area, and garage that is virtually as long as it is wide. So there's a long wall of buildings there. I was surprised to hear the planner refer to a low number of windows. As you can see, there's 11 significantly sized windows here. I'm not counting pane. Some of these are triple pane, double pane. But right now, there's only 2 windows on the south side, One of them is into the garage, one is on the second story, which, as I've said, is 20 meters from our lot line. Under this proposal, we will have a significant increase in the windows. And in the main house area, the proposal only 3 meters from the lot line. Of course, the garage does step back. And then the final comment on the garage in terms of the projection of the garage to the road. So I must say, I did, you know, I had a good positive conversation with the new owner, so we weren't arguing or anything, but I did say to him, you know, with all due respect, I found it's misleading. When the planner, for example, cited our property of 54 Rothwell as an example of where the garage projects in front of the house. So the projection at our house and 6 of the 8 properties he refers to is less than a meter. And often has to do, like Rothwell isn't a straight grid line road, it has a bit of a curve. If you measured from the garage front to the road, it might only be because the road is slightly curving inward as it goes by our place to say it's a meter. So, you know, in their figure 1, there was 20 some odd homes they looked at. So there were only 8 of 20 where it was closer, and 6 of those 8, you're talking less than a meter. So to me, to sort of say, well, this shows that a projection of a garage that is as deep as the house is, like it is as long as the house is deep, is consistent with the neighborhood design. This is an exceptional, you know, increase in the projection. The only other similar property, and we mentioned in our letter, on Wick, the garage projection is roughly 20 to 25% of the house depth. This is 100%. So this, I'm just surprised that the application would represent to this committee that this is consistent with anything in the neighborhood when it's not consistent with anything in the area. And we walked around and just visually verified the property. So thank you. That's really our submission on those points. But really, just to sum it, you know, all we're asking is that if the side yard be 5 meters on our side, just like on the other side, which is still a significant reduction from the existing, and if the main home be moved 5 meters towards the road, now don't, as you've heard, there's 36 or whatever it is meters already from the road, it's significant. The backyard is actually being quite squeezed by the increase in mass. So to move the home 5 meters forward and to increase the setback from 3 to 5 meters, we think is a good compromise that at least satisfies some of the loss of privacy, the loss of light, the potential increased noise and all of that this development would bring about. And we'd like some protection for the existing vegetation that the application refers to. So that's it. Thank you.
All right, thank you, Mr. Paul. I just wanted to mention, though, to be very clear, there is no height issue here at all. So I know it may, you gave evidence about the lack of, you know, some sunlight penetration, that kind of thing. That's not like, yes, that's an impact, but it's not an impact that's related to any of the variances that we're dealing with today, not really. From that standpoint, I just wanted to caution you that it's not really a massing or a height thing for us. Questions for Mr. Paul, though, for clarification, anything? All right, thank you very much then. So thank you very much. We're going to go on to the next speaker. And I think what I'd like to do is actually get a number of issues, and then maybe we'll have a discussion with Mr. Kershaw about some of those things. So is there Ms. Brammer?
Yes.
Yes, okay.
Yes.
So we'd like to hear from you as well. All right. So Ms. Brammer, you're actually representative of the Property Owners Association, right, for Rothwell Heights?
Yeah. I
All
am.
right. Okay.
Thank you,
Then,
Madam Chair. Thank you, Madam
please.
Chair, and good evening, panel members. I'm Jane Brammer, and I'm Chair of the Rothwell Heights Property Owners Association. Before I begin, I'd like to echo Peter Hume's comments earlier this evening about the effectiveness of your staff's management of the files. And from my perspective, it's in relation to public input and public comments. So thank you to Christine and staff for that. Thank you, panel, for this opportunity to speak. We have previously filed a written submission regarding this application, to which I would like to add the following remarks. Our association, now continuously active for over 60 years, addresses issues of relevance to the continued protection of our community character, our environment, and in so doing, the environment of our city in some small part. I'm here today to speak to the preservation of side setbacks, especially in R1AA zoning. Mr. Kershaw made a comment about this particular file where the variance for setback was similar to one requested at 18 Oriel last month. And I'd like to point out that I believe the variance requested, or the impact of the variance requested for this site, is greater than the impact for 18 Oriel in the size restriction. You will have read the description of Rothwell Heights in the city planner's report, and you heard some description from Mr. Kershaw. You'll understand that the larger lots in our neighborhood attract those who want to build larger houses. And as many of the area's original homes have been changing hands in recent years, a considerable amount of new development has been taking place. The bylaws in place for these properties are generous and allow for flexibility in design and siting of larger new homes. Until last month, and for the last 10 to 15 years, to our knowledge, and I have personal involvement for that time period, all new homes have been built within the existing relevant bylaws and guidelines of the time. And so now we're compelled to ask the following question. When replacing a single family home with a single family home, and when building on a lot that is large and unconstrained, why is it considered good land use planning for a proposed new home to encroach into setback spaces? Such encroachment might be considered to be good land use planning if it were enabling intensification or some public good. But is it good land use planning to accept such variances for single family homes on R1AA properties that already offer generous building space? And isn't it the setbacks that help protect the city's tree canopy, the neighborhood green space, the neighbor's privacy, and the neighborhood character? And I'd like to refer to a comment that James Paul made concerning the deciduous trees along the property line at the back of their property, and his concern that a 3-meter setback between the trees and the excavation is challenging to the trees for survival. So an issue with the 3-meter setback. So with regard to the application for 58 Rothwell Drive, we're concerned that the variance requested for the combined interior side yard setback will have unacceptably negative impacts. Therefore, we respectfully ask the panel to consider these factors in assessing the application. Thank you.
All right, thank you, Ms. Brammer. Any questions for our speaker this evening? All right, thank you. I'm going to ask then, is there anyone else? I don't have anybody on my speakers list, but is there anyone else out there in the public that would like to speak either for or against this application? Yes, I have a somebody, Anato. Come forward, please. Mm-hmm. Yeah. All right, so we'd like to either see or hear you.
Can you hear me?
Yes, I can hear you. So can you please give me your full name and your address, please?
My name is Anatoly Konyushin. I'm the owner of the 58 Rothwell. Can you hear me?
Yes, I can. So you're the owner, sorry, of 58?
Rothwell. I'm the
Okay,
owner of
all
the
right.
58
So what would
Rothwell.
you,
It just
okay,
a couple of comments regarding to Mr. Paul comments. Like he's commenting about loss of privacy, and he's counted, let's say he said 11 windows. There's only 3 windows that are part of my daughter's bedroom. The rest of the windows are garage, which is could be deleted. Some windows are in a basement, which is if somebody's standing in the basement at the ground level, there's no way they can see anybody on his backyard. The other windows that he's counting, part of 11 windows, is it's literally like a screen porch, which is 20 feet, 20 meters away from his property line. That's regarding his windows. Hedges, yes, on the plans to show hedges. It doesn't necessarily say cedar hedges. The hedges that were there, they're not going to be affected in any way or form by the excavation. Most of the trees that he's referring, they're on his property. They're even further away from the property line. Like I don't see how our project is gonna affect his privacy. His you know, the sun rises also on the east. His property backyard faces east. I don't see how my house is gonna affect his quality of life. Most of the area where people entertain, it's in the living room, dining room. There is no windows there that's gonna affect him. My screen porch far away. Pool area is not being changed. Therefore, if there's any parties, anything that's going to affect him, it's in a pool area, which is not going to be changed. The pool is in good condition. Like, I don't see where his concern is. I offered him, if any hedges are destroyed by construction, I will pay out of my pocket, or I will maintain them the best we can. You know, nobody can guarantee that they're going to survive. What else there is? You know, the garage, well, the garage is the garage, but I don't see how his points are valid in this situation regarding his privacy, his enjoyment of his backyard. You know, his backyard is meticulously maintained, it's beautiful, but I don't think he's I don't see anything that's been done on his yard next to my property. He's probably 30 meters away where his stable is, where his barbecue is.
all right. So thank you for your comments. I think, does anybody have any questions for the owner? All right, thank you. Is there anyone else in the public who would like to speak either for or against this application? All right, so I'm going to call the public hearing portion closed at this point. And I'd like to get a few clarifications from staff. Ms. Ramirez, please, if I could see you. Just a quick question. I'm looking at your staff report because at some point I was getting a little confused. So I thought maybe I'd have another look at this. So I see, and I'm on page 3 of your report, Ms. Ramirez, if you want to follow with me. And it has to do specifically with the discussion about the setbacks at this particular point in time, the side yard. And I note that you say here, staff note the minimum side yard setback 3 meters is being respected. And then you talk about the northerly interior side yard will be 3 meters in the south. So if I understand your comments right, then and looking at the application, just confirm for me that we're not asking for any side yard setback reductions. Is that correct?
Through you, Madam Chair, I apologize for the confusion. So the minimum required setback, 3 meters, is being respected on both sides, but the total combined interior setback was increased as a result of infill 2 provisions. And so on lots with a lot width greater than 36 meters, they are required to have 40% of the lot width be provided as a total interior side yard. So while the minimum is being respected, the total interior side yard setback is not being respected.
I see. So it's because it's a combination of both sides. It's not meeting the full amount. All right. Okay, I get it. So it's really just that the house is overbuilding on its width in terms of the envelope. Is that correct? All right. Okay. Just wanted to make sure I understood that. Okay. Does any member of the panel have any further questions or clarification from staff at this point? Or yes, Mr. Hindle?
I was just curious if we're planning to tie to plans in this case. Because I think if we're not tying to the site plan, that might give an opportunity for the owner and residents to potentially shift the house and kind of move around within the envelope that's provided.
Well, it seems to me that if we approve it and we don't tie it to plans, then I don't actually see the benefit then in some ways, Mr. Hindle. I guess I'm just trying to understand your logic. So if you could.
Yeah, so I'm just thinking that in some ways, if we say tied it to elevations, but not necessarily to the site plan, in conversations with the neighbors, we may be able, the owner may, should they so decide, be able to shift the home a little bit further south or a little bit further towards the road to play with some of these concerns that have been raised by residents.
Huh. How does the rest of the committee feel about that?
Madam Chair.
Yeah, I'm so sorry, Mr. White. It looked like Ms. Willis was going to say something, so I was kind of looking in her direction. So, yes.
I'm kind of thinking, I don't think there'd be a lot of flexibility in terms of on the lot, sort of side yard, side to side movement, because I think what we're talking about here is establishing a new minimum requirement that that reflects the numbers that we have in the application. So, like, in terms of the closeness to the side property lines, I don't think that there's any flexibility there. Am I correct in that? Maybe Ms. Ramirez can comment on that.
Yes. So, Ms. Ramirez.
Through you, Madam Chair, if you didn't tie it to the plans file, then in theory, you could adjust the house to be a little bit, instead of having a 3 and a 5, you could have a 4 and a 4 because the total interior side yard variance is reduced down to 8.13, I believe. So, I mean, you have a little bit of play if that is something that the committee would like to do.
All right, and is that, Mr. Hindle, then pretty much what your thinking was then in this regard, is that because there isn't a lot of play, right? So we're talking about either it's 3 on one side and 5 on the other, or 4 and 4, or now you're pushing it more towards the other side.
Yeah.
And so I don't know.
Yeah, certainly it's within a couple of meters of play. But my thinking was specifically because the neighbors to the north have come forward with their specific concerns, it might allow a little bit of adjustment as the plans are refined. I'm not super fussed one way or the other, but I thought it might be an option.
All right, Ms. Willis.
Yeah, along the same line, I was just wondering, the neighbor to the north had suggested pulling, I believe I heard him say that if it could be pulled forward a bit, that would also ease the situation a little bit. And I'm just wondering if we could ask the applicant or the owner whether or not that's something that they would consider, is whether they could move it a few meters forward, or whether there's something that prevents that from happening. It doesn't look to me like it would impinge on the variances that are being requested.
Can I answer the question?
Yes.
Yes, you can. Please go ahead.
Pulling the house to the front, I don't see an issue with it. Pulling the house to the other side, I see an issue with it. There is, on that side, there's a very two large corner, like Christmas trees, large trees. If we pull the house towards that side of the property, those trees might not survive. When I had a talk with my other neighbor, Mr. Padmos, I assured him that I will go out of my way to that these trees survive, because these trees really provide him with privacy from my house. While on the other side, it's a deciduous hedges that are almost as tall as the house that's being proposed. And the hedges, the hedges do not die just like this. Large trees that are 50, 60 years old, it doesn't take much to kill them. While the hedges that are deciduous hedges, they don't die. You can excavate next to the hedge right next to them, and it will survive. You see, pulling the house front, I don't see an issue. But moving to the other side, we will kill the very beautiful 2 trees, which is, you know, provides privacy for me and for my other neighbor. It's mean like, and shifting a meter, like I don't know if it's gonna provide any relief to anybody.
All right, thank you.
Going forward, yes.
Ms. Ramirez, I just want to confirm with you that if we gave some flexibility to move the building forward, then perhaps to address some of the concerns, just confirm for me that there's no additional, there's no increased relief to any of the variances that are being requested, or no additional. And I know that's a tough spot to put you in, given that it's kind of doesn't give you the time to look at what the impact really might be from a zoning bylaw standpoint, but what do you think?
Through you, Madam Chair, the variances are worded so that moving the house wouldn't have an impact on them. Quickly looking at them, it doesn't look like that they would be impacted at all. I will note that there is a distinctive tree in the front yard, and currently there's quite a big setback from that tree to the proposed house. And so I don't know how far in advance the house could be pulled, but just that there is a distinctive tree there that it was planned to preserve it. And so I would say that just for the committee to note that there is a large distinctive tree in the front yard that is planned to be proposed. Generally, the more distance from distinctive trees, the better.
Yeah, so would that be the one that's got on the site plan, the circle around it, just to,
That's
so
correct.
that okay, yeah. All right, thank you.
If the house is
sorry, can you just let us keep
Okay.
talking to staff if you wouldn't mind. So, okay. Is there any other questions from a zoning bylaw standard for Ms. Ramirez? All right, so I think we've concluded that there would be an opportunity to pull the house forward. If we do not tie our approval to plans, then that discussion can occur, and maybe a slightly improved siting of the house might work. Do you agree, committee?
So Madam Chair, I might suggest that we tie to the elevations, but not to the site plan, so that we have certainty as to what the building, generally what the building footprint and elevations will be like, but not the site plan.
Right.
Although I will note that there was some discussion of potentially removing some windows along the northern side. So maybe at that point we tie to the footprint of the building and not to elevations or site plan necessarily, but that footprint of the building could be shifted where as needed.
Okay, so I'm not, all right. I guess I'm looking for guidance from you, Mr. Belmar, on this for just a moment. When the committee ties its approvals to plans, does it mean the entire bundle of plans, or does it mean the site plan that's submitted? Just need some clarification as to just what that means.
Madam Chair, I would invite some comment from the planner on that question.
All right, okay. Ms. Ramirez, can you help? Can you provide some insight for us?
As I understand, if you tie it to the plans filed, then it's the elevation and the site plan. I have heard decisions worded so that it applies to the variance generally, and that does give a little bit of flexibility to plans examiners when they review the plans.
Okay, all right. Is that too much latitude for us, members?
We have site plans to simply the footprint of the building. That's been done.
Yeah, we don't want to do that. I think that's where it's because we're trying to avoid that, we're getting into elevations, and so I just wanted to see whether or not, in fact, our approvals could be tied to elevations, but not necessarily the site plan. So if we went, and I guess my question to the panel members is, how comfortable are you with going with the wording generally tied to the plans?
Well,
Ms. Willis.
I just wanted to clarify what we're intending here. Are we intending to give the leeway for the owner to pull the building forward if he can and chooses to, or are we requesting that he pull the building forward? And that will be a different sort of wording, I think.
I would, at this point, I think I would prefer the applicant, the owner, and the neighbors to have a discussion about which is sort of the best, and rather than dictate one way or the other.
So could we not
So-
in the decision say specifically that we're tying it to the elevations and generally the footprint, except like specify unless it's to move the building closer to the street?
No, we could definitely tie it to the elevations from what I'm hearing, and generally tie it to the footprint of the building, and leave it there without having to declare on any other position with regards to it. Thoughts?
So I think I heard, Madam Chair, from the Secretary Treasurer that we have in the past tied simply to a footprint and not necessarily to elevations and or site plan. So I would be inclined just to tie it to a footprint in this case, so that then if the owner and the neighbors wanted to say delete or add windows or shift those around, it allows for that flexibility. And then it's just the footprint of the proposed building that is of concern to us in this case. But then it still can shift within the lot, within the bounds of the zoning in place.
Like we're saying the same thing. It's beginning to sound like we're saying the same thing anyway. All right, Mr. White, any thoughts from you?
No, I agree with Mr. Hendel's suggestion. The footprint situation gives the flexibility. I mean, recognizing obviously that we are granting certain minor variances within which the footprint has to be located. I don't have a problem with that concept.
All right, Ms. Markovich.
Yep, I would be supportive of that approach as well.
All right. Yes, Ms. Willis.
Footprint, to me, footprint tells you it's not just the shape of the footprint, it's also the location on the lot. I'm just concerned that if somebody's going to interpret it that, okay, if you move it forward 2 meters, then that's not the footprint that we approved.
I agree with you. I would not go as far as to actually tie it to the footprint. I would rather tie it to the elevations. And, or, you know what, if you're worried about, Mr. Hindle, I think I heard you say that you would like, if there was a will that they could even play with some of the windows positioning. And if that's the case, then let's just tie it generally to the plans and leave it at that. Let the discussion happen. How are you with that?
Yeah, I think that's a good compromise. I think otherwise we could explicitly state in the decision that it's to the footprint of the building without relation to the site plan generally.
I've got to tell you, Mr. Handel, if that's confusing for me, I think I know what I'm doing. So, okay. So, all right. I think at this point, then let's go. If there's no more questions, no more clarification required on this application. And I think I'm hearing you all say that you'd support the application and tie it. And I'm going to go on a limit generally to plans, and we're going to leave it at that. All in favor? All right, I've got 3, 4. Okay, so I think we've got a unanimous decision. We're okay. That's the way we're doing it. So with that, then, Mr. Kirsch, and is it Anto? So I'm not Anatoly. Okay, thank you. The application's granted. So now I'm going to suggest do enter into further discussions with your neighbors and see if you can't work out something that keeps the vegetation in place, provides maybe a little more privacy and sunlight, that kind of thing. And don't forget, at the end of the day, you still will need to do a tree disclosure report which means you're going to have to address all of that anyway. So you can get it done as part of the further consultation with your neighbors. So I'm going to wish you good luck and get out there. And thanks for your input, everybody. We really appreciate it, especially at 10 o'clock at night. So
Yeah.
thanks so much.
And
we have one more, folks. One more application.
Thank you.
So, and last but not least, we're going with 8 and 9. So can I see, please, Mr. Segreto?
Hello?
Mr. Segreto, hello. Okay, so I didn't do the statutory declaration with you, so can we do that right now?
Sure.
Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was first posted on the property to which the application applies for the prescribed number of days before the hearing, and finally that it was clearly visible and legible during the entirety of that time? Do you solemnly swear or affirm that to be true?
I swear.
All right, thank you. So Mr. Segreto, I think we're just going to ask you to provide us with a brief presentation.
Sure.
It's 10 o'clock. So
Yeah.
if you feel compelled to give us a longer presentation, then don't hesitate to do that, but also don't hesitate to do a briefer version.
I'll keep it simple and I'll get right to the point. How's that?
All right, thank you. Thank you.
What we have with, good evening, Madam Chair and committee members. By the way, the application that we have in front of you here tonight is at 910 Woodruff Avenue. The proposal is to develop the property. In order to develop the property, to construct two-story semi-detached dwellings. It's in a it's in an R2G zone, which allows for semi-detached dwellings. The property is approximately 90 feet wide by 149 feet or so in depth. The two variances that I'm going for this evening on all 4 parts would be for lot width and for height. And I'll explain to you for part 1 and 2, it's to permit a reduced lot width to 6.91 meters, whereas the bylaw requires 7.5. For parts 3 and 4, the lot width is 6.86. For parts 5 and 6, it would be 6.87. And for parts 7 and 8, it would be 6.92. The other 4 variances.
Wait. So according to my application here, I guess I just want to make sure. 7 and 8, you said it's, what number did you give me?
6.92.
How come I've got 6.86?
Let me see. Maybe we can look at the site plan there and see what it says there on the site plan. It might be a typo then. I don't know. Let me see.
Oh, you know what? Your application seems to be that on
Yes.
your variances, but it's not what it says on your notice for the consent.
For the consent?
So you know what we can do? We'll just amend the notice right here.
Yes.
And so for B-00155, we're striking for frontage 6.86 and replacing it with 6.92.
That's what it says. Yeah, that's what it says here. 6.92.
On the
Okay.
site plan, you mean? On the
Yeah.
site plan. All right. Okay. Well, let's do that.
So, okay. So, and then basically on all 4 parts, the height, we're asking for a height increase where the bylaw gives us a maximum of 8 meters. We're asking for 9.5. Now, the 9.5 meters, the reason why we're asking for that basically is that we've done 3 test pit holes on this project, and we've discovered that about at 2'7" below the surface, we hit solid rock. So to avoid like big expenses and whatnot and everything, we thought that we would ask for the height in order to blast and to hole ram and go further down into the ground. Now, my client has discussed this proposal with the surrounding neighbors. My understanding is that he did meet with the neighbor to the north of him, and there was an issue with a tree to the north side at 900 Woodruff, but he did come to terms with the neighbor, and he is willing to reimburse the neighbor for that tree. So he did discuss with his neighbor to the north. To the west as well, he spoke with the other neighbor, Mr. David and Barbara Clark, and they had some issues with respect to a chain link fence, and I believe that my client has agreed to put up this fence. They also had some concerns with respect to the lot grading and drainage, and I believe my client has assured them that we would be applying for a lot grading, drainage and servicing plan, and that all the existing surface and the new surface drainage that would be self-contained on the property. I got 2 letters this morning, I believe it was, or yesterday, from 2 neighbors to the north on Georgina. I believe the addresses are at 2240 and 2242 Georgina. And unfortunately, I don't think Roberto had a chance to talk with them or meet with them, but I think they had some concerns, and possibly the concerns might be for the height. If you go to the land use map, I don't know if there's a land use map there, but if you go to the land use map, you can clearly see that there must be at least 40, 45 to 50 feet from the back or their semis to the proposed buildings that we're doing. So there's plenty of spatial separations between these buildings, and I believe that they're semis as well. When you look at all the other performance standards that we have on this property here, you can clearly see that we have a 7-meter front yard setback. We have over 14 meters in the back, which relates to 46 feet in the backyard. And then all the side yard setbacks are met. So essentially, there are other semis on Woodruff Avenue, and I guess 2 or 3 rows down, there's a cluster of them. And I don't know if the photos are there that we can show, but there's a Chicago private. You can clearly see that there's some semis there, and they're actually 3 stories, even though it's a different zoning, I believe, but they're allowed to go 3 stories high. And I think we're like only 3 doors away from that, proposal. But again, the reason why we're going for that height is because of the rock, and only the rock. Other than that, we wouldn't be doing that. So that's basically the application that I have in front of you right now.
All right, thank you. Questions for Mr. Segreto, the committee? Okay, I've got a couple for you, Mr. Segreto, just quickly. The height of the actual height of the floors, so floor to ceiling. What's your floor to ceiling heights in those units?
I'll tell you, the basement is 9 feet. The ground floor is 9, and the second floor is 9.
Well, they're all 9. So you could shave some. You could shave some.
No, we could, and my client is willing to do that. Like maybe we could possibly make the basement 8 feet and make the second floor 8 feet, but on the ground floor, I would like to keep 9. So that's basically taking off 2 feet. That would be 0.6 of a meter.
Right.
So rather than 1.5 meters, you're taking basically half of that off.
So Mr. Segreto, have you recalculated what that height requirement would be then? Like you would still need a variance, but have you figured out what that would be?
Yeah, you have, right now we're asking for an increase of 1.5 meters, correct? To 9.5. Right. So if you take the 1.5 meters minus 0.6, you'd be at, I guess it would be 0.9. I'd be asking
0.9 meters. Okay, all right. Yeah. I just wanted to get that information from you.
And we would be willing to reduce. Sorry, we would be willing to reduce the basement by 1 foot and the second floor by 1 foot.
Okay, all right. Fair enough. Fair enough. And we've seen a combination before, so that's fine. The only other thing, do you have any kind of streetscape evidence to show how it relates, that height? Proposed height now, not the one that we just discussed, but the proposed height actually relates to the remaining buildings on that street. I just want to get a sense for how it's fit in.
If you look, there are other semis that we've done on that street as well. I think they had a couple of pictures up there a minute ago, but at 890, 888 Woodruff, you'll see a semi that we did there last year, which is roughly at that 8-meter height. The difference is this one here has garages, and the one that we are showing you has the surface parking. But from a height point,
Yes, but are these the same zone? I think you said they weren't
Yeah,
the
well,
same.
the semi is, the one with the, at 890 is the same zone. Yes, it is.
Okay, all right.
Yeah.
Okay, so that's it for me in terms of questions. Again, back to the panel. Just want to make sure before I go to the speakers, you've all had your. All right, so I'm going to open the public hearing portion. I'm looking for Mr. Clark. I see there. In fact, I see two David Clarks. Looking for Mr. Clark to join us. I think we're getting there. Okay. Mr. Clark, you're on mute.
Can you hear me?
Yes, we can hear you.
Okay, well, the only thing I did talk to Roberto regarding the fence, and that's okay. And the other thing was maybe the committee can talk about this on the drainage. I understand drainage is supposed to go to the Woodruff Avenue. And I guess my concern was that with the larger footprint that's going to be there with the doubles versus the single was there, it's going to be far less surface area to absorb water. So my main concern is that water drainage is somehow taken care of, so we won't get any flooding in our backyards.
So that, Mr. Clark, is a condition of approval. In fact, it's just typical. In fact, when there is this kind of development that they need to do a grading and drainage plan to ensure, in fact, that that there's no impact on neighboring properties, pre-redevelopment or development and post. So that would be addressed as part of that process.
That's good.
And approved by the city. So it's an approval by the city. This isn't just, it gets done and then it gets shelved. It's actually approved.
Okay, thank you.
Have you any other questions or comments?
No.
All right, any questions for Mr. Clark from the committee? All right, I'm gonna then call the next speaker, which is, I think it's Mr. Kazay. Mr. Kazay. I'm gonna call again, Mr. Kazay. Are you with us? I know it's late. Sometimes we lose people, there's no doubt. All right, I'm gonna go to the next speaker on my list. So Ms. Marota. Again, Ms. Marota. Okay, I think we might have lost those speakers. I'll come back. As anyone else in the audience, in the public, would like to either speak for or against this application? One last time, Mr. Kazay or Ms. Marota. Okay, we're not seeing anybody come forward. So on that basis, I'm going to close the public hearing portion of hearing on this application. So, okay. All right, committee members, have you any further questions for clarification from anyone, or do we want to entertain the, we're not hearing from anybody else, but do we want to entertain reducing the height requirement? Yes, Ms. Willis.
Is it possible to put, I'm having some computer difficulties where I can't seem to look at the plans while I'm talking on the meeting. So I'm wondering if it's possible to put up the elevations of the plan so we can look at the building height based on the roof line.
Yes, we can do that. So Ms. Willis.
I don't have difficulty with the pitched roof, with the variance as requested. I think with a peak and 1 point, what is the difference is 1.5 meters. I'm okay with that as is.
All right, anybody else? Any other thoughts on the committee?
Yeah, I would agree with Ms. Willis that the 9.5 as originally requested is fine.
Okay. Anybody else? All right.
Madam Chair, I agree. I think we saw at least one of the other examples along the street where I think the building height was 9.65 meters. And I mean, it didn't look out of character, out of place in terms of the neighboring properties and what's happening with the new development in there. So I'm fine with the application as is.
All right, Ms. Markovich.
Yeah, I think I'm fine with it as is.
All right. So Mr. Segreto, I'm going to say, no, I'm not okay with it as is. I don't believe I had enough planning evidence to show me a streetscape that gives me any comfort that this is really the right height for this. So I wish I could just say yes to the rest, but not to that. So if it's so, I may actually make sure it's in the decision that the chair would have preferred to have seen better, more evidence with regards to the height. So. And you know what I'm talking about, Mr. Segreto, you know the days of Anthony Bruni. He would have never let you get away with that. So, so please, for me, get me better streetscape evidence for the next time, if you will, please.
Thank you very much.
All right, so I guess everybody I'm guessing we're supporting as is. All right, Mr. Segreto, there's a ton of conditions.
Yes.
You've seen them all. I hope you're
I've heard
okay.
about the noise condition, and you know what? We're prepared. The noise study, we're prepared to do that, and all the other conditions, the cash in lieu of parkland. I've read through them all, and I think I'm okay with that. All the overlay, et cetera, et cetera.
Perfect. In that case. Committee, I think it's unanimous. The application is for consent and for minor variance is granted. So thank you very much.
Thank you, committee. Thank you. Good
All
night.
right, enjoy whatever's left of the evening. And
Okay.
with that, committee, would somebody please move to adjourn the meeting? Yes, Ms. Willis, seconded by Ms. Markovich. Okay, great. Good work, everybody. It was a long night, but thanks so much. It was great. Sorry, I got lost there. I'm going to make a formal complaint to Bell. So, but anyway, it was great. I'm not going to keep anybody any later. Thank you, staff. Have yourselves a great evening. Good night.
Thanks.
Nice.
Bye.
Thank you.
Good night.